In item number 313, hearing it. My lord, I want the accommodation just today tomorrow, my lord, if it is possible.
Item
313, analogous method. I've taken consent from the.
Okay.
Yes, I've taken consent from them. Only for today tomorrow, my lord.
Okay.
18th or 19th, any date may be fixed.
Okay. List on 18/1/2024 as prayed for by Mr. Amnath, Learning Council for the respondent.
But one, two, my
Respond number 2, senior counsel. Huh? Respond number 2, 12/13.
I'm surprised.
Okay. You say both sides are represented.
May I please, Your Honor? My lord, I beg to mention item number 21 of the supplementary list of today's. Because today we have some difficulty, my lord. Can it be on some other date, Lord? With the consent of the other side.
List after answering due vacation as prayed for by Mr. S. Chetial, Standing Counsel for respond number 2 and respond number 3 and 4. Okay. Entry order passed today stands extended till the next date of listing. Yes.
Listing हो गया आए तो कोर्ट condemnation delay of
Give it to the court master. Prayer for listing, give it to the court master. They will have to make some adjustments. All prayer for listing, give it to the court master.
Well, I'd like to.
Hello, beg to mention item number 9, joint prayer, my lord. So
I have to respond, my lord.
it may be after 3 weeks, my lord, in February. We have newly engaged there and planned.
This 2014 matter, 10 years. List after answering due vacation is prayed for by Mr. M.J. Barua, counsel for the appellant. Both sides are represented. Huh? So it is made clear that matter would not be adjourned on the next date of listing.
Well, I'd like to mention item number 14. This is the hearing matter, RSA for hearing. Look, I pray for 1 week time, but one thing, I could not contact the petitioner. I'll inform or
Item 14.
one for. I pray for 1 week time. There's a second appeal for hearing.
14, but you are not representing them.
The GA Assam is there.
Hmm?
GA Assam is there. But for
Oh, acha, for government. Okay.
I'll
Okay.
inform the petitioner or if Lordship wants that, I can reiterate the pair when the call, matter is called.
You have not taken consent.
I could not.
Acha, okay. Then didn't you pray when the matter is called?
Lordship.
Okay.
Lordship,
With the consent of order said, I beg to mention item number 19. Lordship, my senior is out.
19.
19, Lordship. My senior is out of station. Matter may be taken after vacation.
Okay. You have taken consent of the other side? Okay. Both sides are represented. List after answering view vacation is prayed for by Learning Counsel for the UFO.
SC income tax.
For the respondent numbers, respondent number 1. No, sorry, respondent number 2 to 5. Okay.
Lordship, I beg to mention item number 3 and 6. With the consent of other side, the matter may be adjourned for today due to illness of my senior.
T.
3 and 6.
T, you are not there.
Lordship, both are similar matter.
Similar matter.
Both are similar matter, Lordship.
Okay, you are for the appellant. Or you are for respondent. Okay. Both sides are represented on the prayer made by and counsel for the respondent. List after ensuing view vacation. Okay.
To be spoken to item 18.
Yeah, there was a mistake in the order. There are two dates given. So this matter has been brought to the notice, it has been brought to the notice of the court that in the order dated 22/12/2023, a typographical error has crept in. And whereas at para 7, notice was made returnable on 29/1/2024. But in para 13, date of listing is 22/1/2024. So accordingly, the date appearing in paragraph 13 can now be read as 29/1/2024 instead of 22/1/2024.
My lord, in para 6 of the order, it was recorded at the learned counsel for the applicants as referred to cross-examination. And with regard to position and thereafter last two line, the applicant's name were mutated in respect of the suit line and also admitted that the applicants had a house on the suit. No, no, actually applicants' names are not mutated over the suit. Applicants' name are not mutated over this.
Okay. Moreover, in paragraph 6 of the order, the statement, inverted commas, the applicant's apostrophe names were mutated in respect of the suit land, inverted comma closed. Would stand deleted as the as Mr. A.K. Rai, counsel for the applicants has submitted that the names of the applicants are not mutated in the suit land. Next paragraph, this order shall be read together with order dated 22/12/2023.
Top of the list, item 1.
May I please, your lordship? Lordship, my senior is out of station.
These matters are not being adjourned. You can just wait and take notes.
This is your lordship, madam.
Yes.
Under here, the respondent as the plaintiff, madam, have filed a suit for recovery of money, madam. And concept of work was allotted to him, madam. By
Just a moment.
here, madam, substantial.
Just a moment. Yes.
And here, madam, substantial question law was framed on 22/7/2009, madam.
Yes.
The question was that, madam, whether on the facts and circumstances of the issue involved in the suit and materials available on record, the finding arrived by the learned court will that the work was presumed to be completed by the plaintiff is perverse. Now here, the contention of the plaintiff was that, madam, he had completed the particular work, and therefore he is entitled for the total amount. The work was for rupees 11,74,310. Exhibit 2 is the work order, madam. And this is the admitted position that he was paid 2 running bills. Madam, in the plain itself, he has stated my lord, page 43, para 3, my lord.
Lordship, Lordship, my apologies. Can she stay and take notes, Lordship? Can she stay and take notes, Lordship? Obliged.
Page 43, my lord.
Just now. 43.
Of the plane. Para 3.
Yes.
My lord,
What is the trial court finding?
Yes, before that, madam, kindly for a moment, madam, page 48, the retail statement. Madam, this is also important. Why you have not paid the amount? The remaining amount of rupees 5,59,000. 48, madam, last para 10, next sub-para. It is relevantly submitted here that the date of completion of the work was 6/5/1992, and as per the terms and condition of the work order of the said work and the agreement, the said work was to be completed within 3 months. Was it found, madam?
Yes, please continue.
But yes, within 3 months you are supposed to complete, but unfortunately the plaintiff neither completed the said work within the stipulated time, nor he cared to complete the remaining portion of the work, even work order after 2 letters were issued to him. These are 2 letters we executed on 9/11/1993 and 28/12/1993. And 4/11/4/12/1990, sent by the defendant to the plaintiff, requesting him to complete the remaining portion of the said work immediately. So the question of non-payment of balance amount of 2,59,550 only to the plaintiff by the defendant out of the total amount of so and so towards uncompleted remaining portion of the work does not arise. This is our condition. We could not complete the work. Now, my lord, issue number 4 is issue number 4 has been dealt with. Issue number 4 is whether the plaintiff pays the 13 months of the judgment, whether the plaintiff completed the work within the fixed time fixed by the defendant. Now, my lord, the finding is that page 6, issue number
Page?
Page 16.
60.
16.
16.
Yes.
You see, the court rejected your claim as because you did not produce the MP books.
That is the my submission. Malad.
Correct.
Malad, now, whether the particular work is completed or not, that can be very well ascertained by producing the measurement. And we sought for producing the measurement. But the plaintiff objected to that. It can be shown from the trial court judgment.
No, you see, that was rejected, but order 29 rule 27 in the appellate judgment, I did not find. Did you file an application under order 41 rule 27?
For that purpose, 79/2007 order, by which my petition was rejected. I have flagged in the record, pink color. That order says, kindly see, the order. 79/2007.
of the trial court.
Yes, madam, wherein my application.
Oh, that's okay. It was rejected. But what about appeal?
Madam, the appellate order judgment has said that we have not challenged that attempt finally.
No, you see, for that, still you won't have that. Although I have not read your memo of appeal.
Madam, because I am submitting, madam, the order is very.
No, you
relevant
see
to-
that, you see trial court, for the purpose of perversity, that would not be a perverse order. because-
The order itself said this will be taken, whether additional evidence produced in the measurement book is required or not, that will be considered at the time of hearing of the appeal. This is the order.
Appeal order.
79/2007. This is the one order passed in my petition. Tag mark, pink color, madam. It is passed in appeal, madam.
Yes,
79, madam.
yes,
So you found that order?
yes,
And
yes.
then, my lord, page 5, kindly see the last portion of the order. ma'am. Hearing of the appeal in the merit is not yet been commenced, last paragraph. As such, the power under clause B cannot be involved. In this contention, I have relied the decision of the so-and-so, wherein it is held that the appellate court cannot exercise its power under 41 Rule 27(1)(b) of CPC before commencement of hearing of appeal on merit. Only in course of hearing appeal on merit, if it appears to be expedient for rendering effective decision for any other substantial cause, the learned appellate court may require additional evidence. Hello? Now, my lord, how does this deal with? The court has said, appellate court has said, additional evidence is not required. Now, see, Lordship, my lord, page 21 of the appellate court impugned judgment, my lord, para 35, small paragraph, my lord.
Page,
21, my lord. A perusal of the record of the trial court reveals that the defendant appellant never made any prayer before the trial court to allow them to produce measurement book. During the time of trial, the said measurement book was in the custody and possession of the defendant, and still the same has been in their custodian possession. Well, this finding is wrong because of the fact that, madam, Lordship, now now, from the trial court order that we sought it, the measurement to be placed, and they objected that this is there, madam. Page 34. But it starts from page 34, 10th line of the paragraph. madam. And the
Yes.
line started with 10th line, madam. Plaintiff has the 10th line. Plaintiff has to prove that he had completed the work, but plaintiff could not produce completion certificate as well as the final bill. MB book is the document to show the completion of the work. It is the duty of the plaintiff to produce those documents. plaintiff did not bring those documents, but plaintiff had objected when DW1 wanted to show measurement in the court. Now, my lord, since this is the I sought for, and they have objected, because in a contextual matter, how much of work has been completed, that could very well be, my lord, get it from the measurement. And therefore, on the basis surmises and conjectures that he has completed the work, this finding, and that I did not wanted to produce the measurement book before the learned court below, trial court, this finding is wrong. And for to come a complete decision and complete justice in this matter, my lord, that measurement book was the, my lord, material before the court below. My lord, to produce, and there is no occasion for the defend plaintiff to object to that, my lord. And on this, my lord, the two decisions only, my lord. I was only on the point, my lord, is my case is for, argument is for remand of the matter for a time period within maybe fixed, my lord. For that, we will produce the measurement, how much of work he has completed, my lord, because most of the amount we have, 9 lakhs and what we have paid. Now 2,59,000, since he has not done any work, it's a government money, my lord. Therefore, we have not paid. And on that basis of the measurement, if he is entitled, he will get. And only three judgment for taking additional evidence. 7. It will be. 2007, 14 SCC matter. Here paragraph 15, 16, 17 and 18. Well, here mostly is that the court must say whether evidence is required by it to do complete justice for parties for pronouncement of the judgment. So by the order dated 17/9, my lord, 2007.
Just on. Mm. Mhm. Mm. You see, this is the LCR for the trial court. You find out that what do you call that order where you wanted to produce the or your petition where you wanted to produce the document and it was refused. I'm not getting it. Right. Huh? Like it has been moved.
It is in the appeal, man.
No, you see, you are showing us order where the trial court in the trial court DW1 or the defense witness
DW1.
wanted to produce that MB book, and there is an objection recorded. That objection,
There is no petition.
there is no petition, there is no order.
Yes, but my lord, in between the my lord, cross examination of the witness, my lord, this is my instruction, my lord. The DW wanted that to be placed because he did not. place
Then
the-
you see that no substantial question of law is made out. The reason is very simple.
In the trial court, that is not there.
It's very simple. You see, DW cannot produce a document in evidence which is not entered in the list of documents. That's number one. Number two, you can refer to a document for refreshing of memory, but it can't be tendered in evidence. This is the second part. The third part is, you see, for a document to be entered in the record, in the trial court, you'll have to file an application under Order 8 Rule 1(3) so as to make that document as a part of record. If it is not made, you see, in the appellate court, the case would be that you are trying to fill up the lacuna. In the trial court record, if you can show that in the cross-examination you could have demolished the non-production of the MB book is fatal, then I would have understood that you have a sequence of chain of events. Number one, in the cross-examination of PW, you asked him a question that was not answered in the affirmative, and then what do you call this? The evidence of DW where you wanted to tender the document, but that was refused. Then order 41 to 27, because you see what judgments you have given, I don't know. But in that case of Ibrahim, Supreme Court says that you should have availed the document and the opportunity and then refused.
Here the judgment 2007 says, my lord, for bringing a weak piece of evidence, this is not applicable. But for evidence, in the opinion of the appellate court, this is required, and this is a good evidence. My lord, on that count, my lord, para 15, 16, and 17. my lord.
Mr. Das, you
Here,
see,
my lord.
I'll tell you why. You see, when it comes to 105 CPC, order which is passed in the suit can be challenged in the appeal. That is permissible within the meaning of section 105. Correct? Just check it out.
Other orders, yes.
Hmm?
Other orders. say
Yes,
it's
other orders.
expressed. Like, no appeals in light from any other meeting in court, the original or actually some The GP's appeal from error defect irregularity any order affecting the decision of the case may set forth as ground of objection in the memorandum of appeal.
Now, under 105(1), the other orders or irregularity could have been assailed in the appeal. Now, when it comes to second appeal, you see, second appeal, we only decide the question of law, not the question of fact. Now, how in exercise of power under section 100, we can appreciate the we can deal with the non-appreciation of the, not only appreciation, non-appreciation of your application for additional evidence, because you see, when it comes to second appeal, then rejection of order 41 rule 27 cannot be a substantial question of law. Because a mere error
Yes.
does not give rise to a substantial question of law.
Right.
So it can only be either perversity, non-examination of the evidence on record, non-examination of the pleadings, wrong reading of the pleadings, wrong reading of the evidence.
My argument is on perversity. Perversity because this order 79/2007 passed in my order 41 rule 27 application. Thereby it was stated that the requirement whether the measurement book is to be used as a exhibited or not, that will be taken care. That will be taken care at the time of hearing of the appeal. And in the hearing of the appeal, the judgment says, I have not tried to produce, as a lawsuit has dealt with that. But my lord, from the evidence and from the judgment
You know what has
itself,
happened in your case? What is that order? Order of the rejection of 41 rule 27. What is the date?
79.
79. Look at the last paragraph of that order.
No, this is rejected.
So once it is
And this
rejected,
But my lord, just above paragraph, my lord, this is the finding that it will be taken up if it is required at the time of hearing. And moreover, my lord, the second argument is, my lord, that order 41 rule, my lord, 31, that a point for determination. Point for determination, the appellate court under section 96, my lord, appeal. My lord, normally a point of determination is to be framed. And here, point of determination is also not. And on this count, my lord, two judgments I have placed, madam, how the first appellate court was required to deal the matter, my lord. And for that also, my lord, the Honorable Supreme Court has remanded the matter back for considering a point of determination. Here, my point of determination, whether actually the work was completed. Because, my lord, while dealing with issue number 4, the court has gone into that aspect. My lord, so far the requirement of additional evidence is concerned. And how it is proved, my lord? There is
just a minute. Come to that appellate judgment, where is that?
The judgment speech, my lord, started 11. Paragraph 18 and 19. Paragraph 18, 19, and 20, my lord, here it is stated, my lord, that others contractor have completed their work. And therefore, the plaintiff has also completed the work.
Where? Para 18.
Para 18, 19, 20. The work here is, my lord, for hardening, for construction of civil work, for hardening of the rig side. No, it's a concrete work.
Okay, please come to these judgments you have placed.
Here, my lord, 2007-14 SCC, my lord, 257. Here, Mohan Reddy versus Network in represented by the MD.
Yes.
My lord, here, my lord, paragraph 15, I'm allowed to read. My lord.
15.
Yes. High Court, in our opinion, failed to apply a provision of Order 41 Rule 27 in correct perspective clause AAB, clause 1. Refers to three different situations. Power of the appellate court to pass any order thereunder is limited. Who exercising jurisdiction under the appellate court must arrive at a finding of one or the other condition minimum that they are satisfied. A good reason must also be shown as to why the evidence was not produced in the trial. 16 manner.
Yes. Yes, please go ahead. I'm hearing you.
16. The respondent application category stated that the books of accounts have been misplaced and the same were discovered a few days prior to filing of the said application while the official was being said. The High Court unfortunately did not enter into the situation at all indicated here in before. The High Court proceeded on the application if clause B of sub rule 1 of rule 27 order 41 was applicable. 17. It is now a cited law that the condition precedent for application clause AA of subclause rule 1 of rule 27 order 41 is different from clause B. In the event of former it is applied, if it would be for the applicant to show that the ingredients of conditions precedent material there is satisfied. On the other hand, B to sub rule 1, 27, order 41, CPC is to be taken before the appellate court is bound to consider the entire evidence on record and come to independent finding for arriving at a just decision. Reduction of additional evidence as been by the appellate was necessary. The fact that the High Court failed to do so, in our opinion, amounts to misdirection in law. Furthermore, if the High Court is correct in its view that the responsibility have proceeded on the basis the suit is entirely based on check, where it was not necessary for it to file the books of accounts before the trial. Finding category would not have been arrived at that the same was in fact required to be proved as to enable the appellate court to arrive at just conclusion. The Supreme Court in state of Gujarat versus also from the dying municipal corporation. Not that paragraph is being focused on. Though the appellate court has the power to allow documents to be put. Example 4127 CPC. The requirement of state court must be limited to those cases where it is found necessary to obtain evidence for enabling pronouncement of judgment. These provisions did not entitle the appellate court to let the fresh evidence where even without such evidence it can produce judgment. It does not entitle the appellate court to let the fresh evidence only for the purpose of pronouncement of judgment in a particular way. The appellate court should not pass an order as to patch up the weakness of evidence of the unsuccessful party for trial court, but it will be different if the court is itself requires the evidence to do the justice between the parties. The ability of pronouncement of judgment is to understand the ability of pronouncement of the judgment satisfactorily to the mind of the court. But merely different, it is not sufficient to issue such direction. While saying so, however, we do not mean that the court in an appropriate state should preclude from considering the applicability of clause B. We are therefore of the opinion that the improved judgment cannot be sustained in case the respondent may file additional evidence in support of application 41 Rule 27 within 2 weeks from the date of receipt of copy of the order. Our case is that, my lord, application is already there. And that was disposed of by order dated 17/9/2007, saying that this will taken care at the time of hearing of the appeal. So therefore, on this context, my lord, we were saying that, for a complete justice, my lord, the additional evidence may be taken into account. Next, my lord,
Can you tell us what are the exhibits? Exhibit 3 is legal notice.
yes,
Advocate, exhibit 5 is a reply.
reply to the legal notice. Exhibit 2 is the work order.
Exhibit 2 is work order.
And my lord, exhibit 4 go. This way issued by the defendant to complete the work. These are the reminder notice, my lord. Exhibit 4 go. And ho, GH, my lord. Here, my lord, exhibit 5 is important because this is the reply by which, my lord, we have said that as per above referred notice from the advocate, we have tried to find out the details of payment or payments due. It is to inform you that as per note and details available with the department, like handing over and taking over note dated 28/5/1995, as well as letter from C. Bora, this is advocate letter, my lord. No violation, no liability kept. No liability statement is there, hence nothing is outstanding in this. I was referring to the new statement.
It's a strong word. In issue number 4, what is the date of completion of work? Is it given? Is it answered?
Malad, no. Because the finding is that Malad, he could not produce any completion certificate. Since others have completed their respective work, including the road, therefore it has been presumed to be completed, the work has been completed. But this is the wrong submission, this finding in our humble submission. Look, in fact,
Just a moment. Yes, after this 2007, which judgment you are relying on?
About 2015, 17 SSC, 7 months.
Yes.
Here paragraph 12 and. Here also no sir.
Yes, Ram. Yes.
Here, my case is that if this finding recorded by the trial court is correct, then our case is covered by rule 40, order 41, rule 27, the 1A. The court from whose decree the appeal is prepared has refused to admit evidence. Trial court refused. Here, from this judgment, there are 12, they stated like this. From the opening was rule 21-7, quoted above, it is clear that the parties are not entitled to produce evidence. Opening is not entitled to evidence, my lord. Whenever oral or documentary is, but for the 3 reasons mentioned above, the parties are not allowed to fill the lacuna at the appellate stage. If it is against the spirit of the court of allowed party adduce additional evidence, without fulfillment of either of the 3 conditions mentioned in Rule 27. In the case if no application or move before the trial court seeking scientific examination of the document exhibit 4, nor can it be said that the plaintiff with due diligence would not have moved versus an application to prove the documents relied by him. Now it is to be seen whether third condition 1 contain Rule 1, Rule 1 of Rule 27 is fulfilled or not. Judgments have been discussed. Now, the Honorable Court, my lord, para 18. To consider the argument advanced on the appellant has also perused the law laid down by his court as to exercise revisional power under 115 to court in such matters. So, claiming the scope of revision in this matter, except additional evidence by lower appellate court, to be accusation or any other substantial cause. This court has held as under. The words for any substantial cause must be read to what requires. It's set out in the commencement of the provision so that it will the other substantial cause, the appellate court requires additional evidence. That the rule to apply notice by the privy counsel is under these circumstances, power could be exercised. Therefore, when the first appeal court did not find it necessary to allow the applicant will fail to understand as to how the High Court put in exercise of power 115 has ignited efforts as order. When the applicant requests of evidence to propose exercise arises or not at any other circumstance. When first appellate court passed the order on the file, order 41 or 27, the whole appeal was big. And the first appellate court was to fail to understand as to how the High Court with such order. Here additional evidence was allowed by the appellate court. Now, my lord, this judgment is relevant 2022-7 SCC 247. Here, this is up to the Honorable Court. Para 7 and 8, up to the Honorable Court, whether the additional evidence required for complete certification or the evidence or for is a material evidence or not for deciding the case. Para 7. it is true that the general principle is that the appellate court should not travel outside the record of the work. You cannot take any evidence in appeal. However, as an exception, Order 41 Rule 27 CPC enables the appellate court to take additional evidence under exceptional circumstances. It may also be true that the appellate court may permit additional evidence if the condition laid down rules in this rule are found to be existent and the parties are as of right to the admission of such evidence. However, at the same time, where additional evidence sought to be adduced removes the cloud of doubt over the case. And the evidence has a direct important bearing on the main issue in the suit and permit and injustice of and interest of justice clearly renders it informative that it may be allowed, be permitted on record. Such applications be allowed even on the circumstances it is in which the production and additional evidence under order 41 rule 27 by the court is to be considered. So whether or not appellate court requires additional evidence is the unable pronouncement of judgment for any substantial cause of nature. But this is now this is latest judgment of the honorable here, in view of the, in this particular case, in view of the order 79, there is a categorical finding that this would be considered at the time of hearing of the appeal. Now, at the time of hearing, the honorable court, appellate court failed to find out whether the work is actually complete. There is no finding. No completion certificate. We forget about the measurement book, my lord. No completion certificate would be produced by the plaintiff. Therefore, the proof has to the contention that he has completed the work remain to be proved. And on the basis of presumption, others have completed the work, he must have completed. His presumption, on the basis of presumption has been held that he has completed.
No, you see, there is a reason for that. Your work is only the foundation work of a rig. Correct. Now, assuming that you have not done it, the others, the second contractor is required to complete the wall. You're only to do a foundation. That means I don't know the construction of a rig. I have never seen it. Now let us see in a.
And the basement part I have to the plaintiff has to make, madam.
No, it's okay. So therefore, in the normal buildings which are constructed, the pillars are put in, the base is made ready, and that is the foundation work. Correct. After foundation work comes the parapet walls, those outside walls, everything will come in. Now, if you have not completed the rig work, if you have not, if the plaintiff has not done this rig work, it is not hardened it, did not cement it, then how will you allow the second contractor to start the work?
Here the answer is that he has completed almost 70% because we have paid 9 lakhs out of 11 lakhs. And so far that is not a record. So far the remaining 30% is concerned. In a humble submission, that for whom they have completed the remaining that was required to be on record. That is not there. Now, the proof as to how much he has completed, he has asserted before the honorable court. I have completed the work for 11 lakhs and more. Therefore, I am entitled to the entire amount. So that burden is not satisfied.
No, you see, in a normal contract, what happens is that in all the government contracts, you may take it any works department. The normal rule is that you give them a letter of completion, they'll do a joint measurement.
Right.
Once there is a joint measurement, the amount of work is quantified.
Right.
Now, supposing a contractor comes and says that I've done my work, and you don't produce the measurement book, which is the which is considered to be a final authority on the nature of and the work done. That is one part. There is a second part which we have to take judicial notice. You see, I'm not aware of your contract. But in the state PWD contract I have to form, what is required is that the bills would be made monthly. Now, insofar as the PWD is concerned, this experience I have gathered when I was there in your place. The PWD will not make a bill, not accept a bill which is made by a contractor. Supposing a contractor, for that, any authority,
Yes.
uh,
Executive engineer or some,
but any authority, I'm speaking of PWD, but let us take any authority. A contractor gives them a unilateral bill. They will not accept it to be correct. They will say that there has to be a measurement. So therefore, if a contractor gives a, what you call this, either a running account bill or a final bill, unless it is prepared by their own department, normal thumb rule is that it's not accepted to be a correct bill. Now, what does the contractor do in that case? He says, I have completed it, he gives you a notice. In reply, you say that, well, according to me, there is no liability due. That is your reply. He gives a second notice, you say the same thing, that according to me, in the record, there is no outstanding bill. In one of the replies, you say that unless you complete the work, in one of your letters, you say that unless you complete the work, we will invoke risk and cost.
meaning
Correct.
here we have to engage another one.
No, that's okay. Whatever is your intention, you say we invoke risk and cost. Correct. Because when I'm reading, I don't read it thoroughly. Correct. I don't read it by heart and make it by heart. So,
Very meticulous.
no, not that. But you see, that is your reply that you will invoke risk and cost. Now you don't do it. Risk and cost is never invoked. And you say that we are going to make that rig. The rig is not a what you call it's not priority work. So later on, whenever required, we'll do it. Now you see, there's no continuity. There's a break insofar as the ONGC is concerned. You don't say that risk and cost invoked. You don't say that you did not complete the work and therefore terminate the contract. Unless you terminate, you can't go ahead with risk and cost. So the termination is not there. So where is the proof that it is incomplete?
Therefore, my lord, the joint measurement was taken, para 31. Joint measurement was taken.
Where is that?
This measurement book was with him also.
No, it can't be. You don't give a MB book in duplicate.
Copy.
No works department gives a MB book in duplicate. What they do is that
They
will-
with us.
no, not even original. You see, if the contractor is in your good books, you just make a photocopy and give it to them. But it is not required to be made in a duplicate. MB books is not a document which is made in duplicate.
Not.
It's not.
Page 20.
20?
20.
20.
Para
Para
30.
31, yes.
The court has held that there is absolutely no material on record to show that in terms of exhibit go, joint measurement was taken. And exhibit go was issued asking him to appear for the joint measurement.
Exhibit Go is a letter 28/12/93. Yes, yes, for joint measurement.
Now, my lord, next, my lord, the conduct of defendant, on other hand, by releasing the second running bill clearly suggests that they have waived exhibit Go and Go. These are reminder letters.
No. Quote is correct.
Yes.
You see, I'll tell you why. This, according to your evidence, you have released 5,06,520 and 4,08,240 on 13/3/1994. That is the date.
Right.
So you see, you ask them to come for joint measurement in the exhibit Go is dated 28/12/93.
93, madam, yes.
Correct. So after 3 months, you have given them payment.
4 lakhs was paid on, madam, 31/3/1994. 4 lakhs, 8,000.
No, I don't know. Some evidence says 13/3/94 is the date. I don't know for where it has come. The date of making this payment is 13/3/94.
Yes, correct.
Correct.
This is.
And you will find that in paragraph 17 of the judgment. Page 16. Para 17. So the breakup, I don't know. The court gives a finding that second para of para 17, the claim of the petitioner so and so, last running bill was paid on 13/3/94.
Right.
Correct.
Right.
So you ask them to come for joint measurement in 93 and you give them payment in 94. Therefore, the court says that perhaps you have waived it. What is wrong in that finding?
This is second running, second year. Madam, 94.
No,
This is
no,
the-
you see,
Actually, this is the final bill, madam.
no. You see,
Second
if
bill.
it is a final bill, your payment register would show that it is paid as a final bill. But it cannot be a final bill unless you terminate the contract.
Madam, therefore, madam, on that basis.
No, in a second appeal, Mr. Das,
Yes.
these are not the questions which are required to be gone into. Just you are making a submission, I am responding to it. Doesn't mean that it becomes a substantial question of law. The fact remains that the substantial question of law, and you are relating it with Order 41, Rule 27 and rejection thereof.
As well as,
Now,
madam,
the
as well
appellate
as-
court in one of the paragraphs have stated that the appellate court does not require additional evidence. That is a finding of fact. Now, assuming which paragraph I won't remember, appellate court in its one of the paragraphs of the order has said that Order 41, Rule 27 is not required. Now, if the trial court says it is not required, how can the appellate court say no, it is required?
Madam, therefore, madam, as per the judgments I just referred, madam, here, madam, the honorable the latest judgment has said, madam, the document which was sought to be brought, as per the opinion of the court, madam, if it is a material one, and if the honorable court finds this is a material piece of documents not produced by either party, which was required to be produced, completion of work, madam, completion of work in my all humble submission, madam, for this and that reason. But there is one finding of the trial court judgment also that, madam, that they have objected. But endeavor to produce the measurement book was all along there. But this is my submission. So, while filing that petition, Order 41, Rule 27, madam, there also, madam, the honorable court dealt with that matter by order to the 79 saying that it will be taken in. Now, how they have taken into account? By saying that you have not right to produce it. But there is a finding. But there is a finding in the trial court order. On that basis, this finding is purpose. Number one. Number two, under Order 41, Rule 31.
Just a moment.
Pending for a long time, my lord. They prayer for, my lord, by fixing a particular time, my lord, this may be taken into account by the Ganesh court below, my lord.
You have a copy of evidence, PW1. Will you open? Yes, sir. You don't have to read it for me, just read it and say the trial court in page 34 of the judgment. It has made a mention that whether the plaintiff is not sure whether he completed the work in 1993 or 1994. Correct. That is, if you at page 34 in the middle, there are contradictions regarding the completion of work where plaintiff submitted that he had completed the work by March 1993 or April 1994.
Is not sure about.
Correct. Now, please see that in the evidence. Where is it? How is it? How is it recorded in the evidence? In the work order, completion of time is not there. 3 months.
No. এই কামটো পুনৰ 1993 চনৰ মে জুন জুনৰ আছে আৰম্ভ হয় আৰু 94 চনত 94 চনত 94 চনত আগে আগে শেষ হয়। Then no data. He said that there was some problem and
No, 94 sonar aage that would mean completed within 2093.
But in my humble submission, madam, that completion is to be proved by producing the completion set. Here completion certificate, why the completion certificate was not issued, my lord, that is not answered. He also says, my lord,
No, he has come to court. He has not duty. He does not have a duty to prove it because he has come to court alleging that he has done the work and not paid.
there was my sufficient is that, my lord, this is the, my lord, prime materials, my lord, prime evidence that he has to prove. I have completed the work, not by saying, placing some documents. Here in this case, completion certificate. And no completion certificate. Since no completion certificate.
No, that means
assessment-
no contractor can come and file a money suit. Contractor says that I have completed the work. Officer is wanted. Officer is not giving me the completion certificate. I have come to court. Please give me my money. And you say that if completion certificate is not there, you can't pay money.
It's quantum made. His case is quantum made. If a person does not have a completion certificate, his case is for the work done, I am entitled to. But for a person, if we give a contract, then he has not completed, suppose, then he claims entire bill, then obviously that will be not paid. He is entitled the work done. And from this evidence also, this is not so very clear when he has completed the work. There is no date mentioned because completion date is important. My lord. And by no reply, he has said on this date I have completed. And there could have been another one more substantial question, whether the judgment of impute judgment is bad for non-compliance of order 41 rule 31.
That is not, can't be a substantial question of law.
And that's- but, only two judgments on this case. Yes, madam. Lordship may consider these two judgments.
Yes.
2017 2 SCC 415 and 2020 4 SCC 31.
2000?
2007 2 SCC.
17, 2 SCC, 415,
I'm sorry, 2017,
2 SCC, 415, yes.
paragraph 12, 13 and 15.
Which part?
Yes.
This is non-compliance of order 41 to 31.
Para 15 directly also.
Para 15. Well, this Laliteshwar Prasad Singh, I've been using it for paragraph. Let me find out, I forgot. Para 12. I normally use it for paragraph 12. Second subpara.
Is well settled. The subsequent one is on the point. 2024 yes.
24 SCC.
Yes.
Yes.
Para 18 directly. This is my case.
Para 18.
18. One. issues have not been, discussed, decided finally. And there is no point for determination who is required by the court to be formulated at the time of disposal of the appeal. The Honorable Court said that your additional evidence will be taken care of the hearing or at the time of judgment. The same Honorable Court could not have said that your petition was rejected, therefore we cannot look into, you have not the revision. But that cannot be the, cannot be sustained. These are my submissions, madam, obliged.
I've got recorders here. Yeah. got it. এইটো কি ভুলতে আহিছে Oh. Just record the submissions, huh? The order will be next. The learned counsel for the appellant. Submissions of learned counsel for the appellant. Number one. That there has been a non-compliance of the provisions of Order 41, Rule 31 within bracket small a CPC. Because the learned first appellate court did not formulate a point of determination in the case. Next paragraph. The learned trial court in paragraph 9 of the order, 9 of the judgment, had made a mention that the plaintiff had objected when DW1 wanted to show MB book in the court. Full stop. The appellant filed an application under, this is number 3. Yeah? The applicant, the appellant had filed an application under Order 41, Rule 27, CBC before the learned first appellate court to allow it to adduce additional evidence to prove the measurement books in respect of the contract work. Full stop. The said the learned first appellate court by its order dated 79/2007 had rejected this said application. Full stop. Nonetheless, in the same order it was mentioned that only in course of hearing of appeal on merit, if it appears to be expedient for rendering effective decision or for any other substantial cause, the learned appellate court may require additional evidence, documentary or oral, to be produced by either of the parties. Full stop. Full stop. However, when the appeal was heard on merit, the learned first appellate court had rejected
Case 21, there are 35. By saying that.
had recorded that recorded in paragraph 35 within bracket page 21 that a perusal of the records of the trial court reveals that the defendant oblique appellant never made any prayer before the trial court to allow them to produce the measurement book. Full stop. During the time of trial, the said measurement book was in the custody and possession of the defendant, and still the same has been in their custody and possession. Full stop. Apostrophe. Inward comma closed. In paragraph 7 of the said order, the learned first appellate court had recorded that the petition number 294 of oblique 07 under order 41 rule 27 within bracket small a, again within brackets small double a, bracket closed, and within bracket small b, CPC, was rejected by order dated 17/9/2007, which has not been challenged. And in view of above, the learned first appellate court had held that the appellant had no ground to raise such a point again before the same court. And in paragraph 38, it had held that the measurement book is not at all required by this court to arrive at a just decision of issue in controversy. Next paragraph. Accordingly, it is submitted that this the appellants have been able to make out a clear case of remand of the appeal to the learned first appellate court for a fresh decision in accordance with law by considering the requirement of allowing the appellant to prove the measurement book, which is required for just an fair decision of the matter in controversy. Next paragraph. It is also submitted that the measurement book was not produced by the plaintiff. And that the measurement book is the only document which records the nature of completion, the extent of completion of a work. Hence, comment is submitted that the said document is required for just and fair decision of the case. This is cited 1, 2, 3, 4, 5. You've given 5 citations. 5 citations. Naam and citation. There is only, okay. Write the order. But Mr. B. K. Das, learned counsel for the appellant. His argument is concluded. Ms.
K. Sharma.
A. Sharma.
K.
K. Sharma, learned counsel for the respondent had,
Sorry, on behalf of D. Senapati.
so on behalf of Mr. D. Senapati, learned counsel, prays for adjournment as as he's not available. So the said prayer is rejected. As this is an appeal of the year 2009 and has been listed in top of the list. Nonetheless, for end of justice, the respondents are permitted. The respondent is permitted to file a written note of submission if required in course of 12/1/2024. Next para. This is reserved for delivery of judgment. By tomorrow evening, you can file it. Tomorrow close of the day, you can file written note of argument if required.
Granted to,
Pardon me?
2 days may be granted to us to file the written argument.
No, I can't keep it pending. But then view vacations will come. By the time I enjoy the vacations, I will forget everything. Correct. You want me to enjoy vacations? Correct. If I enjoy, I will forget everything. No. You can't allow that much of time. Because if I forget, and give a copy to him also if we can do it tomorrow. I'll take a break and come back.
Top of the list, item 2.
Your Lordship. In this regular, I have filed IA for reducing evidence. That is in item number 20, connected IA has come, Lordship. Item number 20, Lordship, supply. Item 20, connected with item number 2. This case, Lordship, suit was for right title, interest and confirmation of possession, and then also suit was decreed, counterclaim was, Lordship. Then one title appeal was filed, Lordship. Then suit was dismissed, counterclaim was also dismissed. court held that lot reduce the original deeds. I came to know that he later on taken the original from the registry office, lordship, and he all along keeping those documents with him, lord. There was not an endeavor by the plaintiff either or by the engaged in those documents. Not aware about the fact that original by the court. I inquired, lordship, he informed me that originals are with me, so I have filed this IA, lordship. January, lord.
Lordship, I'll file an objection,
Just a minute. You are claiming preempted right.
Right title, interest, and
You are the defendant.
plaintiff, lordship. Item 2, your lordship. RSA 112/2009, common allowed. Where of the plaintiff is page 42, lord. trial court judge.
for Mrs. R. Chaudhary and counsel for the appellants. You should notice on this application, the order 41 rule 27. CPC for allowing the appellant dash defendants, appellants dash defendants to adduce additional evidence at the second appellate stage. Next para, Miss J. Paul Leonard, counsel for the respondents, accepts notice. Post of objection be if any be filed. Within 7/2/2024. Within 7. List on 9/2/2024.
Top of the list, Lordship.
Yes, the appeal will come at the top of the list.
Otherwise, the IA will go in the order columns, Lord.
No. Tag this. List this matter along with the connected appeal. And appeal you write. In view of the order passed in IA Civil 102 of 2024, comma, hearing stands adjourned today. List the matter for hearing on 9/2/2024.
Okay.
Item 4.
I for conference of during signing agreements.
How much delay?
There's a 828 days. signing agreement. But I have already narrated the cause of the delay. Railway was not made party for the reference code, and railway came to know after lapse of the long period of more than 2 years. My commission dated 8/3/2017, but judgment was passed on 8/12/2014. There is a long delay, then after following the departmental proceeding, a various of the.
Just a moment.
And level pilot.
Just a moment.
I order dated 20/11/2023, the respondent is remain absent for last 3 consecutive days. ma'am.
You please show how you explain the delay.
Yes, ma'am. Para 8, my lord. Para 8 of that page 5.
Para 8.
Page 5.
Yes.
That after lapse of the long period of more than 2 years from the date of the aforesaid input judgment and award dated 8/12/2014, the concerned authority of the railway had received a communication 8/10/2017 on 14/3/2017 from the office of the Deputy Commissioner Kamrup Guwahati issued by the edition.
Why you are not a party there?
I was not party. So I was not aware of this case finally.
Where is the award?
But award is at annexure 1, my lord. At the memo appeal, my lord. In memo appeal, annexure 1, award.
Okay. Heard Mrs. U. Chakravarti and counsel for the applicant. None appears on call for the respondents, although the name of the learned counsel for respondent number 2. For respondent number 1. Is reflected in the cause list. Mr. K.K. Bhattacharya and government advocate for respondent number 2 is present. Next para. By next para before at the outset, it may be mentioned that the respondent number 1 had remained absent when the matter was previously listed and called on 15/11/2023 and in the order dated 28/11/2020 as well as on 28/11/2023 first of in the order dated 28/11/2023 this court had recorded that the respondents had remained absent on 3 consecutive dates. And for Forensic Justice, one last chance was granted to the respondents for appearance. To respondent number 1 for appearance. No, to the respondents for appearance. Next para. By this application under Section 5 of the Limitation Act, the applicant has prayed for condoning the delay of 823 days, 828 days beyond the period of limitation in filing the connected appeal against the common judgment dated 8/12/2014 passed by the learned District Judge Kamrup Amingao in reference case number. This is against which case?
Mr. Case number 20 of 2000. New number.
In reference case number 20 of 2000.
The new number, phone number. The new number is 211 of 2014.
There is no 20 of 2000.
This reference is the old
No,
number.
just tell me the number. Just why you have to argue for that?
211 of 2014.
2000?
11 of 2014.
I don't know. Just come to page 17 and just tell me which is your case number. Come to page number 17 of your memo appeal and tell me the case number.
Minus 15, at page 3, internal page 3 and page number 13 of another appeal. Serial number 15. Misreference case number 211 of 2014. Misreference case number old 20 of 2000. Sri Gokul Kolika versus Sri Collector Kamrup.
You're reading where?
At page 30 by memo appeal, madam. My deal is Dasman. Annexer 1 of memo appeal. At page 30. The top of this page, madam. Serial number 15.
Oh, okay. Appeal against misreference case number 211 of 2014 within bracket new oblique misreference case number 20 oblique 2000 within bracket old. Next paragraph. In this application, it is projected that the applicant was not made a party in the proceedings of the reference case, which was tried by the learned district judge. Kamrup Amindao. It is also projected that the award, the judgment and award in the said reference case was passed on 8/12/2014, and that after a lapse of more than 2 years, the applicants had received a communication dated 8/3/2017 on 14/3/2017 from the office of the Deputy Commissioner, from the additional Deputy Commissioner Kamrup Metro Guwahati, Kamrup Guwahati, addressed to the Deputy Chief Engineer within bracket con, bracket closed, with a request to deposit the balance decretal amount of rupees 63,05,880.64. And thereafter, this application was filed on 14/6/2017. And in the process, there was a delay of 828 days in filing the connected appeal. Next paragraph. Although none appears on call for the respondent number 1, the affidavit in opposition filed by the respondent number 1 has been perused.
This affidavit opposition is the wrong manner. Here, the learned counsel of the respondent one, changed the or judgment or dated 31/6.
Just a minute, just a minute. First off, amongst others, our defense was taken that this court, by a common order dated 26/6/2013, had disposed of early appeal numbers 1 of 2012 TO2, 31 of 2012, remanding those 26 reference cases to the Court of Learned District Judge, Kamru Metro, by directing all the parties, including the general manager, NF Railway, to appear before the reference court on 18/7/2013.
I beg to submit, my lord. This order dated 31/3/2003 with the 26 cases, the other page. It is not relevant to this case. This is the judgment date, earlier judgment date 23/6.
Okay, please let me complete it, then you tell me. The said order is found to be annexed to this application in Annexure 1. Stop. And a perusal of the same, the court does not find that in the order dated 27/6/2013, passed in there's 26 appeals referred above, there is any reference made to there is any mention made to misreference case number 2011 or 2014 within bracket new, or misreference case number 20 of 2000 within bracket old. Next para. In para 4 of the objection, it has been mentioned that the Learned District Judge Amingao had issued notice to all the parties, including the appellant. But no document has been annexed to show that any notice was sent to the present applicant in connection with the said reference case to old or new. Stop. It has also been mentioned that though it has been mentioned in para 4 of the objection that the Learned District Judge Amingao had issued notice to all the parties, including the applicant. But on a perusal of the certified copy of the order under appeal, it does not appear that the present applicant was made a party in misreference case number 211 of 2014 with bracket new, or misreference case number 20 of 2000 within bracket old. the contents of of paragraph 2 to paragraph 9 of the affidavit in opposition has no relation with the proceedings of to misreference case so and so new and old and new. Therefore, the statements made in the affidavit in opposition, albeit the respondent one is irrelevant and therefore deserves to be rejected. Being irrelevant. Full stop. Irrelevant. So moreover, the court finds the said statements to be misleading as reference is made to 26 reference cases, which does not contain the particulars of the present order under challenge, which pertains to misreference case number so and so old and new. Next paragraph. Next paragraph. Therefore, comma, having noticed that the applicant was not a party to the proceedings of the reference cases before the learned court below, comma, the court is inclined to accept the stand of the applicant that they had no notice of the said reference case, and then notice of the said and then notice and had no notice of the said proceedings. Next, but accordingly, the prayer for continuation stands allowed, and the delay of 828 days beyond the period of limitation stands condoned. Next paragraph. Let the connected appeal be registered and listed in the admission column. Item 5. I think we'll have to continue at second half. We'll not have time. What is this IA for?
I for delay connotation.
How much delay?
Delay of 160 days. Lordship, before that, service on respondent number 2 will be completed because we filed the newspaper publication affidavit. After that.
Okay. Are you seriously objecting to that convention of delay? We'll take it up at 2 then. Yes. Yes, Mr. Goswami. You ask somebody to be here, we'll formally pass an order. I'm not jumping the sequence. I'll pass orders when it reaches. Otherwise, there's some administrative problems. No, that's okay. I'll pass orders, I'll adjourn it, but I'll pass orders when it reaches. You may not be here because since I've taken note of your submissions, ask somebody to be here, we'll pass an order. There's some administrative problems because of my way of functioning. You see, if I pass an order in item 16, and there is no order in item number 15, supposing I don't reach item 15 by the end of the day, and I'm passing an order in 16. There have been complaints coming in that why no order is passed in 15 and then orders are passed in 16. I've got no explanation. Correct? So therefore, I would prefer to pass an order when the matter is in due course. If it is a mention, then no problem. But, in regular court time, it's kind of difficult now. Continue to.
Need this is your lordship. Lordship, notices in the case was sent, lordship. For respondent, it had to take, newspaper publication that flagged one. Otherwise, lordship, the delay conservation, we are praying for condoning the delay of 160 days.
160.
Yes. Lordship, the judgment from paragraph 3 I have mentioned. The judgment in the case was passed on 9/7/2019, lordship. But the legal opinion by the dealing council was given on 28/8/2019, that is after 50 days. I have also annexed this letter, lordship. Then, lordship, after getting the legal opinion, the file was prepared in the branch office and sent to the divisional office at Tezpur, while letter dated 6/9/19, and it was received on 19/9/19. Thereafter, the divisional office at Tezpur had sent it to the Guwahati regional office because appeals are filed from the Guwahati regional office. The Guwahati regional office made a few inquiries about driving license and fitness certificate and also requested for the certified copy of the judgment to be provided, lordship, because the certified copy was not given. Then in the meantime, the turmoil in the state in relation to CA and CAB arose. And certified copy of the judgment was received on February 2020. No, not received till February 2020. Thus, telephonic reminders were made to send them so that the appeal can be filed. As the appeals cannot be filed without certified copy. And then in the meantime, the pandemic started, lordship. And the officials, all the officials could not attend their office, and it was intermittently on percentage basis they were attending the office, lordship. And thereafter the file was sent to my chamber on 22/5/2020. And I gave the legal opinion to file appeal on quantum. And then the approval was given on 25/6/2020. And in the meantime, what happened? The office was declared as containment zone because a few officials they died in the pandemic.
No, these things, whatever happened before March 2020, not post March 2020. So let us say till March 2020, do you have an explanation?
Yes.
But from March till the filing of this application, that is 9 December.
Yes.
It is an explanation only for that period.
Yes, lordship. That 50 days, because we received the opinion, legal opinion after 50 days, lordship. And then the
Oh,
certified.
that is within the period of limitation.
Yes, but certified copy of the judgment was not there, lordship, because of that we could not file. The certified copy of the judgment, lordship, it was applied on 28/9.
No, let us say we condone till March 2020. The certified copy not available, your certified copy or your instructions will be all within that time.
March 2020. No, lordship, certified copy was applied on 28/9/2020 and it was received on 21.
I don't know, in para 3, you see, you have given date of 19.
This is the legal opinion, lordship.
No, the judgment is of 1919,
Yes, yes,
2019.
July 19.
So 20, from 19 to 2020, let us say we condone that. After this, after 1st of March 2020, the explanation till this is filed on 28/12 or something.
9/12/2020.
9/12/2020. What is the explanation within this 6 month period?
The
certified copy, Lordship, we did not receive certified. For that, we waited, Lordship. And due to pandemic, I think the copies were, people found it difficult to get the copies, go to the court and all that. That is the, Lordship, because Lordship will see that the certified copy, Lordship, date is 28th, it was applied on 28/9/2020, and it was ultimately taken on 21/10/2020. It's written at the top of the.
So if you apply beyond the period of limitation, you may not get the benefit of that.
um, So basically the condition at that point of time, Lordship, that is our. For certified copy, we did not get, and without certified copy, we not file the appeal, Lordship. That is one of the.
But you see, you have a panel. You have a definite set of rules for your lawyers. If they don't give it, well, the question is that you see, come to me. If I am not satisfied, I am not hearing you. Correct. So what is the point in hearing you without being satisfied? So if you have a panel lawyer and you encourage this default from 2019 to 20, for 1 year he doesn't give a certified copy and you are still giving him in the panel.
I don't know, is there in the panel?
We
or
don't know,
not,
unless you say that we don't know.
No, because
If he is in the panel, that means you are condoning those.
that is
Those-
not correct. To condone that kind of behavior is not correct. That's true, Lordship.
What is there on merit? Tell us what is there in the merit in the appeal?
It is on quantum, Lordship.
Uh,
It is on quantum. And in the meantime, the claimant, Sanufa Khatun, she died. So her legal eyes were substituted, Lordship.
Because post explanation is it's not very happy.
Lordship, I have just written what is the fact, Lordship, as it is, I have mentioned. And Lordship, in fact, Lordship, many cases, Supreme Court has said that the official, I have the citations, Lordship, Ipokokau as well as
No,
executive
no.
officer.
You see, Lipikao,
57 days.
Lipikao's 57 days, there's a judgment of our High Court, authored by Honorable Justice His Lordship Aftab Mr. Segi, as he was then. He refused to condone a delay of 34 days. Then, following Lipokao, you will find in 2023, again, the Supreme Court has reiterated the same thing. It is reiterated Lipokao 2023.
In the judgment also, Lipokau is mentioned. I have in this executive officer, Antiyun Tan Panchayat versus G. Arumugam. There the delay was 1,373 days. And in that also,
Supreme Court condoned.
that's it.
If Supreme Court condoned that,
Yes, sir. And again, Kachi case, collector land acquisition, Anantnag versus Katiji. There also, the delay was condoned, Lordship, because of the official, Lordship. Someone.
Yes, what do you say?
Lord. The explanation given herein, my lord, are not at all satisfactory, my lord. Because para 3, they have mentioned, my lord, that though the judgment was passed on 9/7/19, but the legal opinion of the dealing council was received by the branch office at Nagaon on 28/8/2019. After 50 days of passing the judgment, but the dealing council did not provide certified copy of the judgment. Office received the copy sent from the honorable court. So office had the copy, my lord, communicated by the honorable court. So copy was with them, my lord. And my lord, their only contention is that, my lord, that there was a delay in receiving the certificate copy. So, my lord, from 9/7/2019 till 19/12/2020, my lord, they filed this on 19/12/2020.
9/12.
9/12. No, my lord. So, my lord, such a long period, my lord, of more than 1 year, my lord, only on the ground of non-receipt of certified copy of the judgment, my lord, may kindly not be condoned, my lord. And my lord, this is a case of 2016. Judgment was passed on 2019, and now we are in 2024, my lord, on condonation of delay. And in the meantime, my lord, the claimant, my lord, she already expired, my lord, and her legal heirs are before your lordship now. And my lord, there are many legal heirs, my lord. And my lord, the compensation amount, my lord, when it is divided between the legal heirs, my lord, it is very little amount, my lord, around 70 to 80,000 only. So, my lord, only on the ground of non-receipt of certified copy, a delay of more than 1 year may kindly be not condoned.
No, but issue of substantial, what do you call, to render substantial justice. Because if there is a institutional inefficiency, and if there's a ground made out, therefore, she's saying that she's only challenging the quantum, that is on merit.
My lord, the quantum, my lord, is being challenged on the basis of the legal opinion. The basis of filing this appeal, my lord, is the legal opinion. And the legal opinion which was admittedly received after 50 days, even then, my lord, the opinion is before your lordship at page 23.
No, you see, we are not examining the advocate's opinion. You see, opinion may be right or wrong, but it's an institution, it can't think. So therefore, the officers will take note of the opinion and take a decision, take a call on the appeal, whether you see the privacy intention of understanding the merit of appeal is just only to examine whether condonation will lead to any fruitful result. So if there's a challenge on quantum, that means we'll have to do that arithmetic and find out whether the quantum is justified or not.
But my lord,
It's not the correctness of that. We are examining it now, just to privacy satisfy ourselves whether any case of condonation is made out.
my lord, at para 4 of the opinion, my lord, at page 24, there is no mention, my lord, as to how this quantum is in excess, my lord. Only it is mentioned that yes, such and such quantum was fixed, but it is not mentioned in the legal opinion. Because on the basis of the legal opinion, they have to come for appeal, my lord.
No.
My,
We can't accept that.
my lord,
We can't accept that.
discretion of the court, my lord, I leave it up to your lordship, my lord. If lordship is satisfied, then lordship. I leave it.
Because limitation, you see, lawyers, you're yourself a lawyer. Now, the opinion is only of a lawyer as in what you call what is it called? It's a it has a value so as to make an opinion. But if they transgress the opinion and set out their own case in appeal, the appeal can't be rejected for that.
such a long period, my lord, on the ground of non-receipt of certified copy, it is an inordinate delay, my lord. More
What
than
is the
1 month.
quantum? It's loss of
12 lakh.
dependence is 7,56,000.
12,35,341.
No, that is after this future prospects.
Loss of dependency is 7,56,000. The prospect 3,02,400. Loss of consortium 440,000. Loss of estate 15. Funeral expense 1,000. Medical expenditure 1,000.
What was he doing?
Could not prove that is on ground that they could not prove the income and occupation of the. I'm sorry, Lordship. This written husband.
Doing business, page 15, my lord. There are 19,
Para 19.
14.
He was doing business and earned monthly rupees 12,000.
Husband, it is not, it should be son, that is a mistake.
Pardon me?
12,000.
12,000.
Taken as 7,000 money.
The accident was due to head-on collision, Lord. That is one ground.
Is taken, my lord, yearly 84,000.
And we are controlling the detail. It cost impose a cost of 10,000 for the delay. Able to be. No. You see, I did not have the LCR, otherwise I would have rejected your appeal now and here. You see, 7,000 is the income. He has got 4 dependents. He was, there's nothing to show that he was not maintaining his 4 dependents.
No, Lordship, only the.
No, it's there in the judgment. I was reading the judgment. It says that he was taking care of his 4 dependents. Correct.
That-
So
in fact,
even if,
it's not-
even if he had no income, he has somehow managed to beg and maintain his family of 4. So 7,000 a month is not unfair.
No, we are basically on head-on collision of 2 vehicles and.
No,
both
it's no.
Other insurance.
In this case, he was coming on the wrong side. The vehicle, offending vehicle was coming on the wrong side.
Said, Lordship. That is what the court has said. Okay, Lordship, 10,000, they should, in fact, if they have delayed, they should also get a fee how the court pays.
This offending vehicle was coming from the wrong side.
Right.
I don't know. I did not read it so thoroughly.
No problem,
Hmm.
Lordship, pose the cause, no problem.
I read 20% and then presume 80%.
At this stage, that is the correct proposition, Lordship, because at this stage, Lordship will not be going into the marriage.
No, I have in fact gone into the merit, and that's why I'm saying I'm admitting it just because he'll get 50% on the what do you call this,
Admission date.
on admission
Yes,
date.
Lordship can fix it next week also. I don't
Uh.
have any-
Heard. This is Adi Mazumdar and counsel for the applicant. And Mr. M. Khan, counsel appearing for respondent number,
Respondent
was
number now
substitute.
11.
respondent number 11.
11?
11 no.
What to 11?
4.
Correction kora is.
By filing this application under second proviso to section 173 of the Motor Vehicles Act, read with section 5 of the Limitation Act, the applicant has prayed for condoning the delay of 160 days beyond the period of limitation in filing the connected appeal. Next, the learned counsel for the applicant has submitted that the impugned judgment was passed. The judgment impugned in the connected appeal was passed on 9/7/2019. But the legal opinion of the dealing of the learned dealing counsel was received only on 28/8/2019. And matter was referred to their to the concerned officials. And during the process of taking a decision, there was some turmoil in the state in connection with Citizenship Amendment Act. And in the meanwhile, the COVID-19 pandemic had set in. So therefore, the learned counsel for the applicant, by taking aid of the order dated 23/3/2020 passed by the Supreme Court of India in suo motu WP with bracket C number 3 of 2020, has invoked the benefit of delay that had occurred till 1/3/2020. So it was submitted that the certified copy of the connected of the judgment impugning the connected appeal was received on when?
Received by the council 21/10/2020.
21/10/2020. And some more days was consumed for the conducting council to file the connected appeal. But then calculation appears to be wrong.
Because that time the registry has calculated, because that time will be excluded.
Now this 3 of 2000 gives benefit from when to when?
When to when, that came afterwards. It was March, this
No,
order.
no, no,
came
you're, no, no, you see, your delay would not be condoned from 19 to during that period. Was that COVID period being?
No. This became effective from 15 March 2020 till further orders. I think that I exactly don't remember.
Sumo 3 will find it.
In that.
The delay condonation.
After this, again, the case came.
No,
up
no,
and
no.
the
What is the beginning point of order in Sumo 3?
15 March 2020.
15 March 2020, no.
It is extended. It was.
No, no. The beginning period would be different.
But it
beginning
was
period-
extended. On 15 March, it was extended.
Beginning period will be different. What is the beginning of COVID, what do you call pandemic? It was, whether it was 2020.
It was 2020, end of December, it started on November.
No, no, let us see,
started-
we'll get it from the order.
COVID started in November 19. China, the first one.
So beginning date is, you see, 2 and 3 orders to so that or extend period of limitation. From 15/3/2020. So beginning date is 15/3/2020. So what is the explanation from 19 to 2020?
Certified copy, Lordship. We did not get the certified copy. Because we got the certified copy in October of 2020. And this started in March of 2020, Lordship. COVID, this Somoto case,
Therefore, it is your negligence.
my Lordship is imposing 10,000.
Therefore, it was negligence from 1919. This judgment is of
July 19th.
July.
And the delay was certified copy as well as these other things, Lordship. And these others contributed to.
No, no,
delay.
then you would not get the benefit. then you would not get the benefit, because then Mr. Khan is right. You got a copy of the order from the tribunal.
But we cannot file an appeal.
No, that is okay, but still if you don't get the certified copy, it is your negligence. For that, why should we condone the delay for that negligence?
So, Lordship, certified copy was not received because of these conditions, Lordship. And Lordship remembers that all the courts were not operating properly to get the certified copy or anything, Lordship. In March, this notification came that the time is extended till further orders. So, Lordship, from March, in October, we could procure this certified copy, Lordship. Though the judgment was passed in, there also 50 days, the advocate took time. And from March, Lordship, since this thing came, and that was the time when we, in fact, we were also not coming to the court, Lordship. We were doing online cases. Lordship. Many times we could not come.
This pandemic was not there in 2019.
Lordship.
Pandemic was not there in 2019.
When the judgment was passed, it was not there, Lordship. But we got the judgment after 50 days. That is the explanation of that time. And then we asked for the certified copy from the council. The council could provide it only after October 2020. And without the certified copy,
I don't think we should extend that limitation for you. Okay, next. The Learned Council for the respond number 11.
1.1.
Acha, 1.1. Okay, 1.1, not 11. Has opposed the prayer for continuation of delay on the ground that the explanation of delay for the initial period before the COVID period is absolutely vague, and that and at the ground that and the explanation of delay fails because in paragraph 3 of the application, the applicants have admitted, applicant has admitted that a copy of the judgment passed on 9/7/2019 was received by the branch office on 28/8/2019. Hence, it is submitted that there's no explanation, no explanation at all for delay that had occurred between 28/8/2019 till limitation was extended for corona pandemic on 15/3/2020 till 28/2/2022 was extended. Next, it appears that the pleaded case of the applicant is that the judgment impugning the connected appeal was passed on 9/7/2019. and that the copy of the judgment as well as the legal opinion was received on 28/8/2019. Therefore, the various the office of the offices of the applicant were legally taking their decision. I filed an appeal on and from 28/8/2019 till the Citizenship Amendment Act within bracket bill bracket close erupted on April 12, 2019. So thereafter, in the month of March 2020, the COVID-19 pandemic had disrupted the court functioning as well as disrupted the normal life of citizens in this country. Next paragraph. The applicant requires to deal with several accident cases, and therefore they ought to have made out a clear policy of the dealing lawyers to report judgments to their pass by the MSc tribunals to their offices. Full stop. In this case, the applicant projects that the judgment was passed on 9/7/2019, but it was reported to their office on 28/8/2019. Full stop. The court cannot encourage such deficiency in the administration of the applicants. Casually deal with orders passed by the learned tribunals. Full stop. It is further appalling that although the applicant projects that their lawyer was at fault, neither they have disclosed the names of the lawyers nor the applicants have made any statement as to whether the lawyer who had defaulted in reporting the tribunal judgment to them is still on their panel or not. So it means that the applicant is taking advantage of their incompetent counsel, advantage of their non-reporting by their counsel yet no actions are initiated against their learned counsel. Full stop. Therefore, comma, while noticing that the that during this period of intervening time from passing of the judgment till filing of the appeal, comma, there were two disruptions, being the first being the agitation of CAA protests, and second, with the onset of COVID-19 pandemic. And as per various orders passed by the Supreme Court of India, in SMWP within bracket C number 3 of 2020 and miscellaneous applications therein being MA 665 of 2021 and MA 21 of 2022, whereby the period of limitation was extended from 15/3/2020 till 28/2/2022. And on considering that it is during this period that the applicant has filed the connected appeal, court is inclined to condone the delay in filing of this appeal, of the connected appeal. Nonetheless, due to inefficiency on part of the applicants to deal with the judgments passed by the awards passed by the tribunal in its expected earnest, the court is inclined to impose a cost of rupees 10,000 on the applicant as a condition precedent for entertaining the connected appeal. Full stop. The applicant shall provide the applicant shall within 15 days from being provided with the account particulars of the respondent number 1.1, shall transfer the sum of rupees 10,000 to the respondent number 1, to be shared with all the legal heads of the original claimant, namely late
Sanufa Khatun. Sanufa Khatun.
How do I spell it?
SANUFA.
Sanufa Khatun. Equally. First of on a proof of such transmission of such transfer of money to the respondent number 1.1, proof thereof shall be produced before the court. Next para. Therefore, with the precondition attached, this application stands allowed by condoning the delay of 160 days beyond the period of limitation in filing the connected appeal, subject to payment of cost as a precondition. Next para. The registry shall now register the appeal and raise the same for admission. We'll give it today. Account particulars
My lord, I'll provide, my lord, by tomorrow.
by tomorrow. Okay. This is the matter on 24/1 in the admission column 24/1/2022 at 24.
Highly obliged, Lord.
Right.
Item 7.
Yes.
Lordship, registered post as well as Dasti service. Therefore, Lordship, I have to please twice. Step Lordship, step Lordship.
Yes.
Two types of steps are allowed. One Dasti service and another is registered post Lordship. I have taken steps in both step Lordship. But here, open court says Lordship in the registered post, there is come answer. They refused Lordship.
No, fresh steps was not received by the section.
On that day, Lordship, some of the court, they should do track twice, but they refuse. So Lordship, date, I'll be again, I'll try Lordship. Another attempt was given Lordship, that attempt also taken Lordship.
No, that refusal was of the earlier notice.
But at that, on the day, Lordship, I submitted there already 2 times I attempt, but they refuse. Again, I'll try Lordship. So Lordship, there was another attempt was given Lordship. Again, I attempt Lordship, another.
No. Don't mix up two things. Number one, initial order was 611. 611, 23 order, you took steps.
Yes.
After that, there is another order 2211. After 2211, you did not take registered post.
Lordship, Lordship, on the day, Lordship, actually the whole thing in Lordship, then I have to I have to make another attempt Lordship to submit the earlier notice Lordship. The Dasti service.
No, that is okay, but you take what you call registered post also. Dasti, we don't know. You see, I do not know the signature. You will bring tomorrow a signature contained in the notice saying that somebody received it. I don't know. I have no personal knowledge of that person signing. Correct. You send by registered post also.
But registered post they refuse Lordship. There is complaint Lordship, they refuse Lordship. Payment they receive, they push Lordship.
They have refused.
The registered post notice are there Lordship in the. In our presence also, in the.
Just a moment. No, if it is refused, then we'll accept it. You're not required to take fresh steps then.
Several times we went there Lordship with the witnesses. But they take.
That's okay. Okay, had Mr. S. Hawk, counsel for the petitioner. Also, he is referred to affidavit of the service filed on 15/12/2023 to indicate that the respondents have refused to accept notice by way of Dasti. First of all, it is also pointed out that as per office note dated 9/1/2024, steps issued by registered post with AD on the respondents were returned back with postal remark refused comma, return to sender. Refuse full stop, return to sender, inverted comma closed, which is available in the part 2 file. Full stop. Accordingly, notice on the respondents is deemed to be duly served. None appears on call for the respondents. This is item 7. Okay, accordingly, list this matter in the admission column after answering view vacation.
Hello.
Item 8 for hearing.
Yes. Today it is other way around. You have a confident smile and he is not smiling confidently. No, not with so much of confidence.
My lord, this is the second. And in this particular case, two substantial questions of law and order.
Yes, I've seen that.
The first, whether Learned Court.
15(1) of Hindu Succession Act.
Secondly, the
Yes.
Lord, only my interest is only on issue number 1.
Yes.
Two they have. So that I would not argue on it. I would confine my argument.
15(1). Okay.
Now, my lord, for this particular problem, what I am submitting, my lord, that originally the land belonged to one Hargadhar Malik.
Just a moment. Let me get the act. Okay. Yes.
Land belonged to one Hargadhar Malik, who happened the maternal grandfather of the family. He had only 2 daughters. The wife also subsequently died, and accordingly the land, Purnidas and Bhutpuri Das, they became the owners.
Just a moment. Yes.
My lord, the dispute is in relation to 6 because dispute is in relation to 6 bigha 4/19 lakh as described in schedule A,
6 bigha.
6 bigha 4/19.
Yes.
And that has been described in
You are the plaintiff for the defendant. You are the plaintiff for the defendant.
plenty.
Yes.
Now, since the original owner has only 2 daughters, Purnidas and Bharupuri Das. So far the Purnidas is concerned, my lord, she had no issue. And so far the plaintiffs are concerned, they are the sons of Bharupuri Das. Bhutkuri Das.
Yes.
Now she died intestate and accordingly they claim that this property belongs to them by virtue of the Hindu succession. Now, my lord, they claim, so far the defendants are concerned, they claim that the father of their father, namely Haroram Das, was adopted by the Purnima Das. Their claim that the father of the defendant was adopted by Purnima Das, Haroram, about 15 years back. That is the crux of the matter.
Father of defendants married this
Not married. He was
adopted.
by
Uh,
Purnima. By Purnida. And that is the crux of the matter. Whether he was adopted or not. For this personal purpose, my lord, first of all, I am taking your notice, the written statement at page 2 of the dependent. That your notice written statement is at page 23, man. Annexure 2. My lord, your lordship will see. They have given the your lord in the dependence place. This dependence place. This is Sagadada, wife Mercury, Bakuri, wife Durga, Gori and plaintiffs, Purni, wife of Pitam, adopted son, Haro, adopted son about 15 years ago. Now, the specific statement which has been made is para 2, my lord. Page 2 of the para 1. Page 24, my lord.
yes.
Para 2. Para 2.
Bharo is BH or PH? Bharo, what is the spelling? PH,
PH.
BHARO. Because in your plaint, you have written Pora. There is a typing mistake or something wrong?
Then, Haro. Haro. H-A-R-O.
No, that's what I'm saying. In the written statement is Bharo, BHARO. Bharo, they are writing. So what is right?
My lord, exactly I cannot say.
Okay, okay.
about Baro or Baro. My lord is from last line, 7 or 8 lines above.
Yes.
They had no time. Have you got it? Sir?
Hmm.
That means the Purnidas. They had no child of them, and therefore they about 15 years ago adopted Haro, son of Purni, as their adopted son under the then prevailing system and customs, and Haro was the brother of Pita, that is the husband of Purni Das. Puri, while alive, made this position. I am not opposing pilot, but that is the pleading matter. That is only the plea. Now your lordship will see. Now they claim, so far this their case is concerned, that during the lifetime of Purni, sometimes in 1976, he gifted away the property in favor of the defendant. And that entry is appearing on the face of the chitta. But no gift deed was produced by them in relation to that one. Accordingly, it cannot be said to be a gift. My lord, here the question arises, when they are claiming that the property was gifted to them, right or wrong, then how they can claim that the Haro was the son of, adopted son of Purni? These are the conflicting. If 70.
No, I don't know. When my child was small, I gave him my birthday gift.
That is a different aspect. They are not claiming that one. They are not claiming. They are claiming that during the lifetime of their father, it was most probably the gift was given or not. But there is only the entry in Chitta without supporting it by the giftee. That being the position, my lord, let us assume for the purpose of the argument, had it been given so, there could have been the statement to that effect in written statement. At the relevant time when the suit was filed, Purni was alive. He died during the pendency of the suit. So there could have been the statement to that effect. So now
No, it is there at page 25. That statement is there. The written statement at page 25. Internal page 3. It says made a disposition of a share of land of so and so by way of gift,
by way of
keeping control over her land, and accordingly, the defendant's names were mutated as far as back in 30/10/1976.
page 25, madam,
Of your memo appeal,
there are three.
first para of this page.
That the suit is not mentioned.
No.
Page
Before that, mutated in the name of Purni, there is no objection, so and so, so and so.
1970.
No, gift is given. They say that gift is given.
Yes,
Huh.
what I am saying, if so far the immovable property is concerned, in that case, the section 123 of the transfer property is coming into picture. If there is no gift deed at all, registered gift, then it has no value in IO.
No, but you see, you have seen the cross-examination of the witnesses.
Yes, I
You have seen that.
Yes,
Now you see, is there a cross-examination on the point that what was the value of land? Unless it is rupees 100 and more.
Yes.
So we don't know about the rate of land at that point of time. In 76, 6 bigger land was how much we don't know.
they have also not stated that that the value of this particular land was less than 100.
No, you should have cross-examined the defendant.
No, my lord, even though at that relevant time, the value of the land would have been more than 100. Neither they pleaded that the value at the relevant time was less than 100 rupees and no right procedure. Since there was no pleading at all, the question of my asking the question, my lord, does not matter. And in that case, it has to be proved that the value of the land was more than 100.
No, just a moment. There's something I wanted to verify. Okay. Yes.
My lord, that is only the one. So that, my lord, that gift is not a valid one. When the defendants are claiming on the basis of the gift in the year of 1976, they cannot take the consistent plea that since their father was the adopted son of Puni, and accordingly they inherited the property by way of inheritance. My lord, now your lordship has already come to the pleading. Now, my lord, so far the examination of DW1 is concerned, my lord. I have the translated copy of it, my lord, subject to correction by your lordship. I am giving all the translated copy of in English language. And only the three witnesses have been examined on my behalf, and 3 witnesses have been examined on behalf of the defendant. Defendant number 1 is one of the defendants, and defendant number 2 is the attesting witness of the gift subsequently executed in 2004 by Puni during the pendency of the suit. And third is the writer of the gift. These are 3 witnesses. Now, my lord, for this particular purpose, I'm taking your lordship DW1.
It will print out.
What is it? My lord, DW1, from beginning to last 7 or 8 lines. Where Purnima and Pitam had no issue. Have you got it, man?
Yes.
DW1. From very beginning, last 7 or 8 lines.
Yes.
Purnima and Pitam, her husband, had no issue. As such, Purnima has kept my father as adopted son. That is the evidence. That is only the example. Now, my lord, in my close examination, last 3 lines, ma'am. I have no knowledge. Have you got it, my lord?
Just a moment. Yes.
My lord, last from below, 4th line. I have no knowledge, only one word. ma'am. I have no knowledge about the adopted son. Since the son of the Pharaoh said that he has no knowledge whether his father was the adopted son. That is the question.
No, you see, this is something I learned. A is a son of B. Is a knowledge derived from mother only. Because the son did not see his birth.
Yes.
Correct. So therefore, if somebody, if the mother says that he is the son of, A is the son of, is my son, she is B, so that is the only thing we know of.
Yes.
Nobody, I don't think I know anybody who has questioned his parents. He or she has questioned his parents and done his DNA test to confirm that whether.
No, my lord, that is not the question. This question has been raised. When Tagore went to obtain the Nobel Prize, then one correspondent put him the question regarding the distinction between fact and truth. He put the question. So what is the difference between the fact and truth? Then he said, pointing the figure to that correspondent, that you are the son of your father is the truth, but you are the son of your mother is the fact. So that is a different thing, value altogether. But here, my lord, he has no knowledge about the adopted son. What he said, that he does not know whether his father was adopted or not. What could be the meaning of it, my lord?
I don't know if this word is only taken, I have no knowledge about the adopted son. Maybe he's referring to the meaning of the word adopted son. The question is only, answer is only, in Assamese, what would we say? In the Assamese, it would be DW1.
Next.
Assamese melody, it says পুষ্য পুত্র করার সম্পর্কে মোর নিজা জ্ঞান নাই।
Nija gyan nai. So I don't have personal knowledge.
He may not have the personal knowledge, but he could have gathered the knowledge from his grandmother, Purna, when she was alive. But even though, my lord, the pleading is entirely defective, and apart from evidence is given, there are variations. He does not say anything even in key.
Wo Nija gyan nai. Nija gyan nai. He's telling the truth.
No, even though, my lord, you know.
No, it will be hearsay evidence. If I acquire knowledge from my grandfather and then say who my father was, it's a hearsay evidence. And hearsay evidence is otherwise excluded.
Even though it is excluded, to be taken into account, my lord, by this honorable. Even though the chief is very important, There he says only that, sorry, he says only, Purnima has kept my father as a adopted son. No further intention.
ওর পিতা পূর্ণিমায় পুত্র হিসাবে রাখিল রাখিল
That is the English translation. My lord.
Hmm.
He kept mentioning as adopted. He has not said that he was the adopted son of. Now, my lord, in pleading, he has stated according to the rights and rituals, he was adopted. Relevant at the age. Now, the burden to prove it was on certificate. Whether that burden has been discharged or not. That, for that one, the evidence are there. He could not succeed in discharging the burden. Now, how this point has been attended by the learned trial court, the learned trial court has not discussed it on this point, whether he was the adopted son or not. That was not discussed. But the lower, learned lower appellate court discussed about it. So far, the trial court judgment is concerned, my lord, so lordship will see issue number 3 and 6 at page 39.
Yes.
May I read this one? Learned trial court. Issue number 3 and 6. Issue number 3 is whether the plaintiff have right, title, interest over the true claim as described in Schedule B. And additional issue 6, whether the plaintiffs have right, title, and interest over A Schedule B.
This land which is said to be gifted is B schedule land.
T-shirt, and during the pendency of the that was gifted because Purnima is concerned, she was one of the defendants. She died during the pendency and prior to his death, she executed it. She died on, my lord, she died on
22,394.
22,394.
Yes.
And the bill, and the gift was executed on 15/2/90. And the suit was filed in 1993, and after her death, the plaint was amended.
This gift deed was on which date?
It was 15/2/1994.
94.
Yes. 94. And she died on
22,394.
during the penalty.
Yes.
So my, the learned time was not discussed this particular point. It was discussed only by the learned lower appellate court matter at page 52. Issue number 3 and 6, my page 50. May I read it, my
Yes.
page 52, my internal page.
Yes.
For the sake of convenience of discussion, these two issues are taken together. In the purchase suit, the plaintiffs have claimed title in respect of 6 Vega Police and 19 Lakhs of land, the escape scheduling of the plaintiff. This was mutated in name of performer defendant Purni Das. Originally, the suit was filed during the lifetime of performer defendant Purni Das, claiming title over the half of the above referred land. Their case is that their maternal grandfather, Harkir Das, was the original owner of the Schedule A. Okay, after his death, his name was mutated in the name of his wife, Kalpuri, and after her death, his name was devoted to her two daughters, Kalpuri, mother of the plaintiff, and the Puni, the performer rebellion, and accordingly they occupied their respective shares since 1974. But from the Dhammavanti, it appears that the names of the defendants also mutated in respect of above land by right of gift for which they have filed the suit claiming title in respect of this share. And after the death of performer defendant Punidas, they have amended the claim claiming title in respect to entire 6 Biga 19 land. But the defendant's case is that the Hargadhar was the owner of 11 Biga 8 lakhs of land, and after his death, the same was mutated name is by Kalpuri, who during a lifetime made the position of the child in favor of two Bhutkuri and Puni, and accordingly Puni got present as the Bhutkuri got 9 lakhs of land, and the name of the plaintiffs also mutated in respect to 4 Biga 9 lakhs of land. Pune married to Pitam, and they had no child. So they adopted Aro, the father of the defendants, about 50 years ago, and during the lifetime of Pune, gifted the disputed land to the defendants. Learned counsel for the appellant, Mr. Salman, has contended that by deciding the issue number 3 and 6, the learned High Court has come to the finding on interpretation section 15(1) of the Hindu Succession Act, but the learned judge did not consider section 15(2)(a) of the Child Act. Defendants have claimed to be the sons of adopted, but equally adoption was never established by the defendant. The learned judge, without ascertaining question of adoption, held that in view of Control section 51 of the Act, the defendants are entitled to the property. Purnima Das, which is absolutely erroneous and illegal. The case of the defendants is that the adoption was made 50 years ago during the lifetime of husband of Punita. But prior to the Hindu Adoption and Maintenance Act 1956, a married woman or widow would never adopt during the lifetime of husband, and after his death, as the case may be, except with the given to her by the husband or the consent of Sapinda. But nothing has been accomplished in instantly for the story of adopting board. The properties that devolve on the plaintiffs in section 15(2)(a) of the Succession Act, who are legal heirs under the Act. So the finding on the issue number 3 and 4 are to be given. Learned counsel for the respondent, Mr. K. Sama, has contended that the defendant has stated about the adoption of their father by Pritam Das and Punni Das, but he said adoption was occurred prior to their birth. The plain and simple mathematical solution that the said adoption was earlier to the year of 1943. So the old adoption of the father of the defendant occurred prior before their But how can it be proved? Mr. Sharma has contended that the law has been settled by the apex court in case of such and such, such and such. And the above written honorable apex court has observed that in case of violation transaction, it is but natural that positive or evidence will be lacking. Passage of time gradually wipes out such evidence. Human affairs often have two leaders on the basis of probability. The entering of the particular mode of proof is insisted upon under all circumstances. If judging whether an adoption pleaded has been satisfactorily proved or not, we have to bear in mind the lapse of time between the date of the adoption and the date of the concerned party required to enact proof. In the case of an adoption that to have taken place years before the same is questioned, the most important evidence is likely to be that of alleged adoptive father had out the person claiming to have been adopted as his son. The latter treated the former as his father and their relations and friends treated them as father and son. I am giving more stress, my lord, on this one. Friends and relations. I am giving more stress upon it because here in this particular defendants have not used any kind of any relative or any of the friends to prove that he was adopted.
Mr. Bhati, it will be very difficult to follow you. I'll tell you why. You see, if you come to page 20, which is your plaint, you have not what you call there's no prayer here with regard to the relationship of the adoption or the relationship between the that Purnima and this Poraram Das. That was never put to question. So therefore, there cannot be an issue whether X was the adopted son of Y, and therefore there is no issue to that effect to find out the relationship, and therefore you see under the Evidence Act. The question of opinion as to relationship will not be material.
Only 50 marriage, section 50. Opinion or relationship.
Where 1150.
Yes. Page 20.
So therefore this question would never have arisen. You see, I'll tell you the reason again. There's a second way of looking at it. You look at that document, which is the sale deed. In sale deed, there is a mention that the land is being donated to the Nati. What is that language used? You see that? To that. Huh?
Grandsons.
No, there's a word, Nati. Nati, I think Nati is a word used. So therefore, the donor says that is the what you call the grandson.
Again, I'm going to give the example. Suppose we are the two brothers. I have the sons and daughters, and my brother has also the sons and daughters. And their sons and daughters will call me also either Dada or not. Grandfather, maternal,
Correct,
maternal,
correct.
simply for saying that the grandsons doesn't mean that they are the sons of the adopted son of the donor.
I don't know, written words to be interpreted in a sale deed, in a second appeal to interpret words given in a sale deed. It would be too far to stretch the boundaries of the court under section 100. No, it's okay. What we are saying is right, because in my community also, everybody who is an elder, we call them uncle or auntie or so forth and so forth. They may not be related to me, but I still call them uncle.
Same service being followed in Assamese community
Hmm.
too. So that merely by writing in the gift book that they are the grandsons of mine, that does not. Because first of all.
No, you see, you see, but to every such distant grandson, this sort of gift is not given.
Gift can be given even. to
No,
the-
it can be given, but I have not seen it being given. Just because somebody is a community grandfather, for that he donates land to X, Y, and Z that we don't know. Otherwise, Mr. Bhatra is also here sitting behind. No, don't stand up. It's my way of conducting myself. You see, even to his grandfather, I called him Tauji.
He is also calling it out.
No, that's what I'm saying. But just because I give a name to the relationship would not entitle me to a gift.
Gift can be given by everybody.
No, I am not denying it. But then you say he will not say in that gift deed, I'm gifting it to my grandson. He would say that he is I love this boy. I treat him as my grandson, and therefore I am gifting it. But he will not say that I am gifting it to my grandson.
Keeping is a different thing, my lord. If they are the grandsons, in that case it can. Suppose if I keep the son of my nephew with me, it doesn't mean.
No, you
that
won't
is
say it my nephew. You see, you will give a name to that relationship. That he's my son of my friend. I treat him as my.
My lord, I don't know the mind of that daughter. I do not know the mind of her.
No, that's why I'm saying. You see, presumption.
donor.
No, you see, I'm speaking only with reference to section 50. In section 50, it is said that opinion as to relationship when reference. Huh?
Section 50.
Opinion as to relationship when relevant. The court has to form an opinion on the conduct of relationship one person to another. The opinion expressed by conduct as to the existence of such relationship. So it falls here. That's why I'm asking you that question.
Yes, my lord, second one, your lordship will see. Existence of the relation or any person.
Who is the family member or so and so otherwise has special means or knowledge on the subject.
Special means of.
No, you see, relationship is not a question, Mr. Bhatti. Relationship is not a subject matter of question. It's not a prayer made. Therefore, this is not a fact and issue where we take where the court will insist on a independent witness to depose as to the relationship. Here, you are questioning the sale deed because he was not a family member. That's what you are saying. But in the document, it reflects that it is a nati. So only that much. My intention is not to not to read more into what has been there in the document, because that would be interpretation of document, which is again a question of fact. Second appeal would not lie.
The text is not properly decided.
Pardon me?
If the text is decided, is based on no intent. In fact, it's not.
In that case, yes. You're absolutely right.
So far, only basis of this one. Whether your lordship will presume that they are the grandsons. and his father was the adopted son. First I told your lordship, we have to confine only upon whether there was in fact the adoption of the father of the baby.
Okay.
My lord, from where I have left, my lord, at
Yes, 52, you were there.
54 miles.
Oh, yes, huh,
54 miles.
yes.
The most important evidence, middle of the plan. The most important evidence is likely to be that the alleged adoptive father held out the person claiming to have been adopted as his son. The latter treated the former as his father and their relations and friends treated them as father and son. There is no predetermined way of proving any fact. A fact is said to have been proved when, after considering the matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Hence, if after taking an overall view of the evidence adduced in the case, they are satisfied the adoption pleaded is true, we must necessarily, that is it. So my lord, this finding is concerned, that is not based on anything. Your lordship has already gone to the first of all, taking in this particular case, no delay. It is not the case of the defendants that there was no other relative. No relative, no neighbor, no friend had been examined in support of this act. They examined only two witnesses, apart from defendant himself. They examined only two witnesses. One is the attesting witness of the gift deed and other is the writer of the gift deed. Now, my lord, I am taking to your lordship. First of all, what he said, the other fellow. PW2. PW2. Then PW3. PW3.
PW3,
PW2.
Ramchandra Das,
No. Dhanwar Ali.
DW3. Oh, okay. Dhanbar Ali. Yes.
My lord, there's nothing regarding the address of Sarna. In two evidence, my lord, PW2. Anwar Hussain. So both are not the neighbors. And both are not the friends. And the both are not the are in relation.
Both are not?
Are in relation.
Okay.
So that at least that some independent witnesses ought to have been examined. Neighbors, friends, and relatives. To prove the spectrum of adoption. Now, my lord,
Yes.
now, my lord, I am taking your worship to the judgment of 1970, which has been referred to. Whether that judgment is applicable in this case or not.
1970 SC 1286.
Yes, 128. I'm giving my copy I have. My lord, I will take your worship.
You are saying this is not applicable.
In the instant case, it's not applicable. Why it is not applicable? In this particular, many documents, many witnesses, many documents were produced to support the adoption, and many witnesses had been examined. In the facts and circumstances of this case, this judgment is not.
Yes.
My lord, from Terra. May I give it?
Yes.
The principal question that you have to decide in this case is whether the adoption pleaded by Shyam Bihari Lal is true and legal. According to Shyam Bihari Lal, Gopal Das took him in adoption on February 8, on the very day he was born. He says that very soon after his birth, his natural parents handed him over to Gopal Das and his wife, who took him over as an adopted son and thereafter performed ceremonies according to the customs of their community. He also pleaded that in the community of Gopala, there is the custom of taking a child in adoption on the very day of his birth. The plaintiffs had denied both the spectrum of adoption as well as the custom pleaded. We may at the very outset mention that Shyamlal Bihari had not been able to establish the custom pleaded by him. Now, nor was he able to adduce any satisfactory evidence about the actual adoption, but he has produced considerable documentary evidence to show that Gopal Das was treating him for over a quarter of century as his son. That is important, my friend. There is a plenty of reliable evidence to show. Here, there is also plenty of reliable evidence to show that close relations of Gopal Das, including Devi Prasad, treated Shyamlal Bihari Lal as the son of Gopal Das, both during the lifetime of Gopal Das and also thereafter, till about the time the suit from which this appeal arises was instituted. As mentioned earlier, Gopal Das as well as his wife died in 1934, and the suit from which this appeal arises was filed in 1946. While considering the question of proof of adoption pleaded, we must bear in mind the fact that the same is alleged to have taken place in 1892, nearly 54 years before the purchase suit was instituted. Therefore, naturally, it was extremely difficult for Shyamlal to adduce any ordinary case in proof of adoption. All the persons who could have known about the adoption are likely to have died. Shyamlal Bihari himself could not speak to the adoption. His evidence is at best hearsay. It is true as observed by the court in such and such that it is well settled that the person who seeks to dispute the succession to property by alleging any adoption must discharge the burden that lies upon him by proof of the factum of adoption is validity. Again, as held by the court in such and such, that in order that an adoption may be valid under Hindu law, there must be a formal ceremony of giving and taking. This is true of the general castes as well as of the Shudra. Although no particular form is prescribed for the ceremony, the law requires that the natural parents should hand over the adoptive boy and the adoptive parent must receive him. The nature of the ceremony varying according to circumstances. In the course of the judgment, such and such who spoke for the court quoted with approval the following observation. The ceremonies of giving and taking are absolutely necessary in all cases. These ceremonies must be accompanied by the actual delivery of the child, symbolical and constructive delivery by the mere parole expression of intention on the part of the giver and the taker without the presence of the boy is not sufficient. Nor are deeds of gift and acceptance executed and registered in anticipation at intended adoption, nor acknowledgement sufficient by themselves to constitute legal adoption. In the absence of actual gift and acceptance accompanied by actual delivery, a formal ceremony being essential for that purpose. That is also the view expressed by, skipping all it, man. There is no doubt that the burden of proving satisfactorily that he was given by his natural father and received by Gopal Das as his adoptive child is on Shyamlal Bihari. But as observed by the Judicial Committee of Praviganj, such and such that although the person who believes that he had been adopted is bound to prove his title as adopted son. As fact here, from the long period during which he had been received as adopted son, even allowed for the absence of children to prove some fact was to be favorably entertained. And that the case was analogous to that in which the legitimacy of person in possession had been accepted. It is in for a considerable time and afterwards impeached by a party who had the right to defend where the defendant orders to defend his status is allowed to by members of the family that in case of Hindu long recognition as an adopted there even a stronger presumption of probability adoption arising from the possibility of the loss of his rights in his own family by being adopted in another family in such and such. Now, my lord, I am taking to your lordship para 10. In case of conventions are the same but nature, that positive origins will be making decisions by creating by both the children. This para is in the by the human affairs often have to be judged. Basis of probabilities, rendering of justice will become impossible if a particular mode of proof is insisted upon under all the second. In judging whether adoption plea date has been successfully proved or not, we have to bear in mind the length of time between the date of alleged adoption and the date on which the concerned party is required to adduce proof. In case of adoption said to have taken place years before the sharing question, the most important evidence is likely to be that of alleged adoptive father held out the person claiming to have been adopted as his son, and later treated the former father as a relation and then treated them as father and son. There is no predetermined way of proving any fact. A fact is that to have been proved. Again, my lord, I am speaking over. Now, my lord, there are 12. Before dealing with evidence mentioned earlier, it is necessary to mention that the High Court has relied in proof of the adoption period on evidence or deregulation such and such. Both of them were the close relations of the wife of Gopal Das. My lord, in this particular case,
You're now reading which paragraph?
12,
12, okay.
both of them were the close relations of the wife of Gopal Das. They are disinterested witnesses. Their evidence is to the effect that sometime after the birth of Shyamlal, Shyambiari Lal, the wife of Gopal took him to her paternal home, where peony berry ceremony was performed. There is scientific evidence to show that this ceremony is customarily performed in the presence of a lady who has given birth to her first child. We see no reason to disbelieve the testimony of these witnesses. In this particular case, my lord, the witnesses have been exact, relatives, and they supported that he is the adopted son. Now, my lord, 13, para 13. Now, coming to the documentary, referred to earlier, it is true that Shyamlal Bihari was admitted to school in 907. In the application made for admission on December 7, the application was signed by Gopal Das. It recites that Shyam Bihari Lal is the son of Gopal Das. This admission of Gopal Das is an extremely important piece of evidence. No reason is given why Gopal Das should have made a false statement in that application. The explanation is someone must have filed in form and Gopal Das must have signed the same in ignorance is not worthy of credence. In executive circumstances, certified copy of deposition of Gopal Das in regular suit number such and such, such and such. That deposition was given on May such and such. Wherein Gopal Das admitted in more than one place that Shyam Bihari Lal was his son. We must come to the executive such a copy of the nomination paper hired by Shyam Bihari Lal for election to the municipal council. Gopal Das was one of the persons who proposed his name. Wherein again, Shyam Bihari Lal was described as the son of Gopal Das. Under these circumstances, the Honorable Supreme Court has decided to stay in case on the basis of the oral evidence and document. In this particular case, there is no oral evidence at all. Apart from, let us forget about the document evidence file. My lord, it is a fact that their names had been registered under the election rules. They did not produce even the proof of yes, wherein their names have been shown as the son of his father's name was shown as the son of Purnidas. No document, no relative has been brought in Rome. No friends have been brought in Rome. And the pleading and the evidence are absolutely insufficient to prove the factum of adoption. He was also the income tax payer and all this. That melody income tax or other documents like this. In this particular, there is no document. And oral evidence is insufficient to believe that he is the son of Purnita. That is the crux of the matter. So that this point is not rightly decided by the. Now, my lord, you are looking during the penance.
Yes.
So my lord, in my humble submission, this question has not been likely guided. And it is a fit case where I will take the my lord, apart from it, my lord, during the pendency of the Punida, prior to her death, he agreed. Now you will see under section 52 of the transfer of property. Without the leave of the court, that gift is all who have been executed. Now, my lord, had the gift deed was not executed, in that case, this matter on deciding that he is not my, he is not the adopted son, decree could have been passed in my favor. Accordingly, that is how the learned appellate court has decided that issue number 4 at page 57. Only this much, my lord. As discussed above in foregoing, it means that gift deed number such and such is hit by the and this issue is answered accordingly. If that is the finding, my lord, in that case, the gift is void. If that is the finding, my lord, in that case, the gift is
Gifted is?
void.
No.
In,
You know the law well. You know the law well.
I know, I understand, my lord. But the decree could have been passed in my favor, my lord. In that case, this.
No, in that case, that your degree will prevail.
uh,
That is the only
my
thing. The
degree-
sale deed remains.
Irrespective of it.
Irrespective of sale deed,
Yeah.
your degree will prevail.
But what I am submitting, whatever the finding has been given, according to this finding, the gift is given. That is my submission. Issue number 1. It is now apart from it, my lord, assuming for the sake of the argument that this gift deed is valid and this land could have been given in gift to the defendant. The total land is 6 bighas, 4 lakhs, 4 kata 19 lakhs. And gift deed is only in respect of 3 bighas, 2 kata 9.5.
3 bigha,
3 bighas, 2 kata 9.5. Even though my lord, for the rest of the land, I rejected. Again, my lord, the question arises whether Shivaji adopted son or not. First of all, they claim a right under the gift deed, and their names were mutated in the year of 1976. Secondly, they claim the right under the subsequent gift deed exit. These two gift deeds itself shows. These two gift deeds itself show my.
but that part is right, Mr. Dekar. That part is right. So far as that A schedule land is concerned, had to be decreed in their favor.
Provided the adoption.
No, adoption is that is with relation to what you call schedule B or 3 bigha land. But what about the remaining out of 6 bighas?
There is a broader issue involved here.
Okay. Okay.
So my lord, this being the position, my lord. Now, my lord, I'm taking to your notice to into successful act. Section 50.
Yes.
Here, my lord, the position, the right of the was denied by virtue of one. And the dependents were treated as the sons of the adopted son of Sunni. And my case falls within the purview of subsection 2A. Because here, he inherited the property from her father or mother. And accordingly, any property inherited by a female Hindu from her father or mother shall devolve in absence of any son or daughter of the deceased. Such and such and such, not upon other heirs, referred to in subsection 1, in order to specify that, but upon the heirs of the father. So that might not automatically on the basis of it, I made that. If the victim of the adoption is disbelieved by the family. That is my sense.
Yes.
Lord, though Purni was made a pro forma defendant in the suit, my lord, in fact, it was a contest between Bhutkuri's sons and Purni as to who is entitled to the whole of Schedule A. Now, if I may just quickly point out, at page 15, my lord, paragraph 5 of the plain, may I read, my lord?
Paragraph.
Paragraph 5.
Yes.
Says that some lands of Dag number 13 of Schedule A schedule land was acquired for defense purpose and compensation for the acquired land was assessed there. There arose dispute between the two sisters, Purni and Bhutkuri Bushra, regarding the apportionment of the compensation money, and ultimately the village committee intervened and settled the dispute between the two sisters in the year 1974. Accordingly, according to the decision of the village committee, the entire land of Schedule A was divided between the two sisters. The entire compensation money and remaining land of Dag number 13 was given to Purnidas. The Basti land and the houses thereon. The land of Dag number 470 was given to Bhutkuri. The land of the other two Dags were divided equally between the two sisters. The eastern half measuring 1 bigha, 1 kotha, 10.5 lachas, of land in Dag number 475 were given to Bhutkuri Bosho. The other half
other half of the land in the above two dags were given to Purni Das, the elder sister. The decision of the village committee was agreed and consented by two sisters by putting their thumb impressions in the proceeding book of the village committee in presence of village elders. Accordingly, the two sisters possessed their respective shares. Purni Das possessed her share of the land through the defendants, and the share of the Bhutkuri was possessed by the plaintiffs. Bhutkuri Bosho expired 12 years back, leaving behind the plaintiffs as heirs. Purni Das was very old and she expired on so and so. So basic claim was that there was a division among the two sisters, and as per that division, dag number 470 was retained by Bhutkuri and the other two dags were divided equally. This was the case set up by the plaintiffs. My lord, against that,
Just a moment. Yes.
now at page 24, your lordship finds the defense. So their story was that this Schedule A land 470 was exclusively theirs. The remaining dagwise, it was divided among the two sisters. So they in a way had questioned Purni's title also. Now at page 24, if your lordship takes up the part of the written.
470 and 1 bigha, 1 kata, 10 lacha of 475.
Yes,
Two land is theirs.
yes. She got the Basti land in 470, eastern half 1 bigha, 1 kotha, 10.5 lachas in 475. The other half given to Purni Das. Now, however, as per the Jamabandi, there are two more Dags. There is no parity. There is another Dag number 13 and another Dag number 304. But it says the land in other Dags, so probably it's a reference to those Dags. However, at page 24,
20?
that's part of the written statement. This is the case of the plaintiffs. Khorgo Das was the original propositus of the property.
Page 24 is defendant.
Defendant.
Yours
Yes,
case.
my Khorgo Das was the original propositus of the property shown here under. At the time of his death, he left behind two daughters, Bhutpuri and Purni, and his wife Galpuri. After the death of Khorgo, all lands left behind by him was mutated alone in the name of Galpuri. Galpuri, while alive before her death, made dispositions of the land left behind by Khorgo, and as per the disposition, she disposed the following lands to Bhutpuri. This is Patta number 37, Dag number so and so, a total of 4 bigha 9 lechas. And these lands have been mutated in the name of the plaintiffs as Patta number 37 of village. They are enjoying these lands in their own right without any interference from the defendants or from any quarter. Neither Bhutpuri nor the plaintiffs ever objected to these dispositions made in 1959. Purni was another daughter of Khorgo and Galpuri, who was given in marriage in Pritam. They had no child of theirs, and therefore they, about 50 years ago, adopted Haro, son of Pura, as their adopted son under the then prevailing system and custom, and Pura was brother of Pritam. Galpuri, while alive, made disposition of the following lands in favor of Purni by endorsement in Chitta, by Chitta endorsement number so and so, and she was given the following lands: Patta number 20, now Patta number 243, Dag number so and so, so and so, so and so. Accordingly, the lands were mutated in the name of Purni. There was no objection to such disposition and mutation since 1959. In 1976, the said Purni made a disposition of her share of lands in Dag number so and so, so and so, by way of gift to these defendants, keeping control of her land over the lands, and accordingly, the defendants' names were mutated way back in 1976. There was no objection then. Purni is an heir of late Khorgodhar and Galpuri, and she has absolute right of her upon her share and Patta land, and none could challenge her right in disposition. Adoption of Haro was made prior to the birth of the plaintiffs. So, these are the two contesting claims. The plaintiffs say that the portions of the suit land was exclusively theirs, and others they have shares in that, half on the eastern side. Whereas we say, my lord, that division among the two sisters have already taken place way back in 1959 when Galpuri divided it between her two daughters. And the plaintiff or Bhutpuri, they had obtained land in another patta, which is patta number 37. And this particular suit patta of 293 was given to Purni as her exclusive share. So basically Bhutpuri took patta number 37 and Purni took the suit patta, which is 243. Old patta is 20.
Yes.
Now, my lord, will take up the findings of the trial court regarding this moot issue as to whether this particular suit patta fell entirely on the share of Purni. That is at page 41.
My lord, may I go for 5 minutes?
Yes.
Page 41, the last paragraph at the bottom, my lord. If we consider
You said, what was your question framed? Whether?
My lord, issue
The-
number 3.
No. You just now pointed
Yeah,
out.
my lord, the question was whether this particular suit patta fell exclusively in the share of Purni by virtue of that mutual division by their mother, where Bhutkuri was given 37 and Purni was given 293. That's the suit patta.
Share of Purni.
Yes.
This is 300. 470.
470. The entire patta, in fact, comprising of 470, 475, 304, and 13.
What are the dark numbers?
Dark number 13, my lord.
30, 30,
13,
13,
304,
304,
470, and 475.
okay.
So our basic cases, all of these 4 ducks comprised in that patta is Purni shared, and Bhutkuri, as in the plaintiffs, took their share in patta number 37, which is a separate patta, not a part of the suit.
Patta number?
37 is what they took.
Patta 37. So patta, yours is, this is,
243.
no, this patta was
This patta was 243.
243. 243, new patta is?
Old is 220. Old is 20, 243 is
343 is new, old is 243.
243.
243 is new.
New.
Old is
20.
yes.
Now, my lord, I'm taking your lordship to this because it has to eventually, ultimately, substantially affect their rights, my lord. Their claim is we have a right over to 293 because we are co-pattadars, as in we are also heirs of Horgan. The case of set up by defendants is there has already been a division between the 2 sisters, and 293 is what the share of Purni is. You took it elsewhere in patta 37. Now, page 41 are the findings.
Page 40, yes.
41. Page 41.
Yes.
The last paragraph, Lord, if the begins with if we consider the entire evidence. If we consider the entire evidence on record, it will be found that according to plaintiff Khogendra Mali and after him Galpuri had the suit land, had only the suit land, and the suit land was divided in between the 2 sisters Purni and Bhutkuri in equal shares, and the plaintiffs are possessing the shares of their mother Bhutkuri, and the defendants were possessing the share of Purni. But according to DW1, Khorgodhar Mali and after him Galpuri had more than 11 bighas of land, which was divided between the 2 sisters, and the suit land fell in the share of Purni Das, and they were in possession thereof. Exhibit 1 and Exhibit 4 are certified copies of Jamabandis of the suit land in the name of Purni Das. Exhibit 1 and Exhibit 4 clearly prove that the suit land has been mutated in the name of Purni Das. Exhibit 1 and Exhibit 4 does not prove how Purni Das got the suit land, but the certified copy of the Jamabandi of Mirzapur village of 1957-64 proves that Galpuri had 11 bighas, 8 lechas of land in different Dag. In patta number 20 old and 37 new, remarks Kaur herein clearly prove that by an order of the ASO dated 15/3/1959, the lands of 278, 12 and 464 have been recorded in the name of Purni in patta number 243, and by an order dated 31/1962, the remaining lands were recorded in the name of the plaintiff as heirs of Galpuri. It also reveals that the name of some other persons have been muted in patta number 37 by way of purchase from the plaintiffs. Therefore, the documentary evidence clearly prove that Galpuri had 11 bighas of land, which she gave to her two daughters, Bhutkuri and Purni. Bhutkuri got land of patta number 37, measuring 4 bighas 9 lechas, and Purni got 6 bighas 4 kotha 19 lechas out of the said patta number so and was recorded in her name in a separate patta number 243. From the evidence on record, it is crystal clear that the plaintiff suppressed the material facts regarding the total land of their predecessor and the division made by their predecessor thereof in between the two sisters. Moreover, PW1 in his cross-examination categorically stated that they have sold out some of the lands out of their share. Exhibit 1 as well as Exhibit Q do not prove that plaintiffs have sold any land out of this patta land. If the plaintiffs would have got their share in patta number 243 and they would have sold some other land, that fact would have appeared in Exhibit 1 and Exhibit Q. On the other hand, certified copies of patta number 37 clearly prove that the plaintiffs have sold some lands of the lands of patta number 37. This clearly proves that the plaintiffs got their share in the land covered by patta number 37 of village Mirzapur, and Purni got the suit land as a share. The fact that the plaintiffs did not get any share in the suit land is fortified by the evidence of PW1 stated in his cross-examination that he has no possession over the suit land. If the plaintiffs would have got any share in the suit land, they would have been in possession therein. Therefore, the entire evidence on record clearly proved that the suit land covered by patta number 243 fell in the share of Purni Das, and she had right title and interest and possession thereof through the defendants. Evidence of PW 1, 2, and 3 that half of the suit land fell in the share of Bhutkuri cannot be believed, inasmuch as PW 1 in his evidence suppressed the material facts regarding the total quantity of the land left by the predecessor, and PW 2 and 3 cannot be believed as they do not know what was the total quantity of the land possessed by Khogendra Mali, and also they did not know how much land and in what dag Purni and Bhutkuri got. Case of the plaintiffs that they got half of the share in the suit land is therefore false. The plaintiffs also claim that the suit land from claim the suit land from Purni Das. This we are not concerned. Lordship is right. Malak.
Let it be on 18th, my lord. As may be convenient. As the part of my.
Remain as part. Malak.
My lord, let it be at February. At February. I would be out of station on
8th
6th.
February.